Take seats, please. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, O persons having business with the Appellate Division, draw near. The attendant shall be heard. Please be seated. Okay, good afternoon, folks. Hope everyone is warm, even in here. We're freezing outside, but that is not a reason to keep you here all afternoon. We have 5.5 hours of argument time requested. The standard speech is we have read the record, we have read the briefs. Please ask for the time that you believe you need to get through your appeal. So that said, first case up, People versus Javier Rosado. Okay, that's submitted. Second case, Rodriguez versus Fawn East 4th Street.
Plaintiff appellant 601, please.
How much time? 6, 1, and 5. Okay. Bledo versus Center for Human Reproduction.
No request 8 and 2, Judge. Request 5.
8, 2, and 5. Okay. Next case is Melendez versus Truffle. I think we're good to go. Everyone good? No? Okay, yeah. So it was submitted. Thank you. Number People versus Darling Alba. I'm sorry? I thought you said 1. I'm like, that's just standing up. So you asked for 5 and 1 and 5. Okay, 5, 1, and 5. Thank you. Harriet Tubman Gardens versus Bluestone.
Plaintiff responded, Michael Hatchett. Request 5.
And you're the appellant, correct? You're appealing?
No, we're responding.
No, I need the appellant first. Don't confuse me. That's easily done, so don't do that. Right, so you're York? You're York Construction. How much time do you want? 5 and 3. Okay. Then the second appellant, Arthur Kahane, architect?
4 and 2.
4 and 2, okay. I need the respondent, Harriet Tubman.
Michael Hatchett,
5 minutes. And the next respondent is the Bluestone?
2 minutes.
2 minutes, okay. So we have 5, okay, so it's going to be 5 and 3, 4 and 2, 5 and 2, okay? Thank you. Okay, Georgetown Company versus IAC Interactive. 8 and 5.
For the respondent, Your Honor, 8, please.
Okay, 5 and 3 and 5. Thank you. And if you know what, if we go beyond the times, we'll just continue asking questions, and we'll do it that way. So it's 5 and 3 and 5. Okay, Experience New York versus 126 West 34th.
Plaintiff appellant 5 and 2, please.
Respondent 5.
Perfect. Okay, so 5 and 2 and 5. Thank you. New York City Liberties NYCLU versus the New York State Court of OCA. 6 and 2. Okay, 5, 3, and 5. Thank you. Great Rock versus Wingtip Communications.
6 for respondent.
All right, 6, 3, and 6. Okay. Thank you. People versus Damien Smith. I'm sorry. Thank you. Okay, 5 and 2 and 5. Thank you. Crandall versus Equinox Holding is submitted. Thank you. First case up is People versus Xavier Rosado. Submitted? That was submitted. Oh, my mistake. Thank you, wing person. Rodriguez versus Fawn, East 4th Street.
Good afternoon. May it please the court. My name is Anthony DeLiso, and I represent the plaintiff appellate, Dan Rodriguez. Simple tasks involving minimal work is how the Court of Appeals determines whether an activity is deemed protected under Labor Law 240 subsection 1 or whether it's just routine maintenance. There is nothing about this $11,000 commercial hot water heater repair and replacement that was simple or routine as the trial court erroneously held. It is undisputed that this hot water heater failed, it was inoperable, and the tenants were not getting heat. In order to perform this repair to the crucial building system, a system that gave hot water to all 5 floors of the building and all 10 tenants who were renting out the property. It was a repair that Mr. Stapor, who was the property manager, could not repair. He did not possess the skills, knowledge, equipment, tools, or expertise to perform this repair. The same thing for the building super, Mr. Allen. He could not perform this work.
So, counsel, your argument then focuses on the context of the larger project at hand, as opposed to just a simple act of replacing a water heater?
Well, it was a large project. While it was the only project that was going on at that time, the repair and replacement of the hot water heater required many, many steps. And if you want, I'll run through them quickly, but in the record, they're on page 680. To take out the old hot water heater, they had to shut off the hot and cold water valves. There was a lot of planning that went into this. There was approval by Mr. Stapor to do this work. And then they had to cut copper pipes, 2 pipes, in order to take apart the system.
That
Remove
sounds
gas
like,
line. Oh, go ahead. I was just going to add, remove gas lines and things of that nature, correct?
Electric, gas lines, they had to drain the system, which the testimony was they didn't know how long it took, but between 30 minutes and 3 hours. This is a 100-gallon hot water tank, massive. And then they had to remove that, bring the new one in. The new one, at a minimum, if you look at the manufacturer specifications sheet, was 630 pounds. And of course, as you know, that's when the accident happens, when it's being navigated down into the basement, down some steps on the hand truck. And
There's still a dispute as to the size of the water heater.
I don't think there's a dispute. All you have to do is look at the Bruce Plumbing Supply work order, which identifies the make and model of the hot water heater, which was A.O. Smith, and the manufacturer specification sheet, which shows exactly how much it weighed at a minimum. The shipping weight, 630 pounds.
it's the shipping weight, but we don't know if you take off if you take it out of the box, because you know when these water heaters are coming at you, they're packaged really well because they don't want to be damaged in transportation, right? So what is it? It's like the old saying, how much does the dog weigh wet and dry, right? I mean, that's the way you look at it, right?
So Justice Owing, if you want to say that there was 50 pounds of wood encasing, the record is,
I don't know.
there's nothing in the record that says how much the wood weighed.
That's true, but you have a foreperson that says it's about 100 pounds versus the plaintiff who estimates it about 600 or 700 pounds. So that's kind of like an issue of fact, separate from characterization of the work as routine based on the foreperson's
And-
experience versus your client who was really a helper.
And on top of that, they're putting this on a hand truck. If it's 600 pounds like you, and like the plaintiff is testifying to, there's no way a hand truck that they're using is going to be able to even do anything. That thing's going to break, all right?
Oh, it was inadequate, Judge. That was not the proper
I
hand
don't know if
truck
it was
to be-
inadequate. Okay, it's inadequate, but I probably wasn't going to be able to move the darn thing.
If you look at, again, the manufacturer's specification sheet, it was at least 2.5 feet in diameter. It was 6 feet tall. The hand truck was 4 feet tall, had a 12-inch wide plate and a 5-inch wide plate.
So that's your position, or your expert position, that it wasn't a sufficient protection device.
That's correct, Your Honor.
It needed to be bigger and wider with double straps or something like
I
that.
mean, the question really boils down to, is it going to be repair, as the case law has said it is, or is it routine maintenance, right? I mean, if it falls into routine maintenance, then 240 goes away. If it falls into repair, you have a 240 claim. So that's sort of where I'm trying to focus the argument of what we have here. And, the life expectancy of these water heaters, they have a life expectancy. They don't go on forever. So that you're expected, at some point, you're going to have to change them out. So is that considered a repair, or is that considered routine maintenance because it's got an either 10-year lifespan or 15-year lifespan?
Well, it's absolutely considered a repair. If we're talking about lifespans of 10, 15, 20 years, I can't consider that routine, and the cases don't support that proposition.
We don't have any case, I don't see a case law. I mean, I looked in terms of water heater, changing something out that's finished its useful life, and that you got to change it out. I didn't seem to uncover a case that says that.
You're right, there aren't any cases that involve hot water heaters. But if you compare this case, because these cases are intensely fact-specific. And I see my time is wrapping up, but they're intensely fact-specific. So Justice Oing, you were on Rodriguez v. Milton Boron, and if you remember in that one, they were
Oh,
changing...
man, I don't even remember what I had for dinner last night. Don't do that.
They were changing the super of a shelter, a homeless shelter, and I read that record. They were changing in one particular unit a smoke alarm, and the smoke alarm was being removed because it was the day before found to be inoperable, just like the hot water heater here. And the super got up on the ladder, was changing it, required him to deal with electric. It was changed from a smoke detector to a hybrid smoke detector carbon monoxide alarm. And the trial court dismissed the case, this department, and your panel found it to be covered work. So if you look at the scope of the work here, the amount of people, so 7 people, welders, had to come in to perform this type of work. So I submit to the court that it was certainly not routine and that the decision should be reversed, and in reversing the decision, granting plaintiff summary judgment on this 240 subsection 1 claim.
All right, thank you.
Marjorie McAteer for respondents, Fawn East and City Urban.
Counsel, at the outset, may I ask you if there's agreement as to the dimensions of the hot water heater?
I can't hear you.
As to the dimensions of the hot water heater, is there agreement?
No, there's not an agreement on it. And one of the points I wanted to make to you is the expert that was submitted, the report that was submitted by plaintiff described dimensions that weren't testified to by the parties. So I think Nassert, who was the plaintiff's supervisor on site.
But the plaintiff submitted the affidavit of its expert, and you didn't submit any rebuttal, so how are we supposed to view that?
I felt the expert's affidavit was based on facts that weren't even in the record. The expert used specifications that she states in her own report were provided by plaintiff's counsel. The expert never went out and went to the building and examined that hot water heater.
Was there
So
an
we know for
invoice?
Pardon?
Was there an invoice?
There was an invoice, but the invoice didn't have the specifications on it. So somehow specifications got to the expert, and she gave a paragraph in her report that says she was given them. So those should not even have been considered, as far as I'm concerned, in an expert's report. And then she talked about the size of this hot water heater and then the size of this hand truck.
And did you submit anything in opposition to that expert's opinion?
We didn't hire our own expert because we felt plaintiff's expert relied on incorrect information, and therefore her conclusions were therefore incorrect.
Well, counsel, just setting aside that point, which might go to the second part of the issue that's at hand, the threshold issue is like, what kind of work was this? And, you know, we have these cases out there. Some say when you're replacing components, that might just be routine. But this particular work, if you look at the work order that's on record at 574, it describes so many different things, although it does make reference to the 100-gallon water heater, but it talks about removal of gas lines, disconnection of electrical wiring, cutting copper pipes, draining the boiler. I mean, this was a much larger, this is more than just replacing one particular component. And while we don't have cases, as was discussed, that was particularly on point, that the Gatson case out of this department is kind of, you know, instructive on that, is it not?
I completely disagree that this is a complex job whatsoever. We all have valves, we shut them off in our homes, the water's shut off. It's very simple. We unplug something and now the electrical's unplugged. There were no gas lines replaced in this case. There was an incorrect statement in one of the statement of facts.
It's not like the case that we had the first part where they actually had to climb on top, weld everything, the big gigantic boiler. It's very different from that kind of scenario, right? I mean,
Right, that was the case where the man was,
right, everything that was described about how this water heater had to be changed out is no different than a residential water heater. Like, you gotta turn off the gas, you gotta turn off the waters, you gotta just disconnect everything and
disconnect, take it out, put the new one in, clip it up, that's it. This was not a complex job, and it was repeatedly referred
How
to.
many hours did it take, counsel, to complete the installation? Wasn't
That's a
it
good
11
question.
hours?
Because from my reading of the transcripts, these people were sitting around for quite a bit of time during the day, sitting on the steps. So they had to wait for the welders to come, they had to wait for the other team to come. So how much actual work was done?
All part of the same job, though.
It was all part of the same job, that's correct. But as far as I'm concerned, my position is that that length of time does not transform it into a complicated job that then falls within a non-routine replacement of a hot water heater.
but this,
Could we
but-
say as,
oh, I'm sorry.
could we say as a matter of law, this was a simple task involving minimal work?
I think that no one's asking the court to make a sweeping decision saying all hot water heater replacements are going to be simple, but we have to look, I think, at each of the cases, you know, as they come up and the facts that were presented to this court. And the facts that were presented to this court don't establish any type of complexity.
And I
You would
get,
agree,
Sorry.
you would agree that the installation of all hot water heaters could be complex?
Installation of all would be complex?
That all of installation of water heaters can be very complex.
That seems to be what the witnesses were saying. It depends on the situation. And one of the witnesses was describing how if you have a building that has, you have to bring it up 10 floors, or it was a white glove building, that adds time to the project. So that seemed to make it more complex for him.
I think one of the factors to consider in terms of whether or not this is a repair or routine maintenance is the size of the water heater itself, is what is sort of needed to actually install it. I mean, there's so many moving parts to this type of scenario to determine repair or routine when it comes to this kind of water tank or water heaters in general. I mean, that's where I'm trying to grasp it. I think it's just it's very fact intensive whether or not it is or it isn't, right? Is it a repair or is it routine? I mean, if it's a 100-pound water heater, that's no different than any residential water heater going in. But if it's a 600-pound water heater, maybe it tilts it the other way, that it's a repair versus routine. You know,
They didn't repair it. They just,
I know, it's just,
no, they just replaced it.
okay. Thank you. We got everything. Thank you.
So Mr. Nasser testified that he believed that the project took at least a day, was not clear. So it was at least a full-day project that required...
But that goes into, again, as I stated earlier, it goes into all the factors to be considered, whether or not it is a repair versus a routine maintenance. I mean, that could tip it in your favor that it is more repair than routine. Because, you know, and I think you would have to agree that it's very fact-intensive in terms of this type of whether or not it's a repair or routine, right?
Absolutely fact-intensive, and I think that if you look
And you're
at,
saying the facts tip in your favor, though.
if you just look at the work order at the record on page 680, it is lengthy, it is long. Those are things that ordinary people without specialized knowledge can't do on their own. It required 3 companies to perform what's being deemed a simple routine maintenance. A plumbing company. So if someone had to deliver this 630 pounds hot water heater to the site, and lastly, welders, which Mr. Nasser testified, he's performed this type of work 1,000 times. Of course he did, he's a plumber, but never had welders on any of his projects.
Because they needed to get that heater in, right?
They had to get the heater in because it was
Yeah,
gigantic.
but that's separate from the work itself. I mean, I'm glad my colleague pointed out, that's to remove the gate, the door, so it could fit through get it through, because it's a narrow opening.
But is it really separate from the work when it's required to do the work?
Okay.
And with that, I'll rest.
Okay,
Your Honor.
thank you.
Thank you.
Bledsoe versus Center for Human Reproduction.
May it please the court, my name is Matt Geyer. I represent the plaintiff's appellants. Your Honors, the plaintiffs went to CHR because Ms. Bledsoe had breast cancer, anticipating chemotherapy. They had 1 child, they wanted more. She went to CHR to have her eggs retrieved, to have embryos created, to have them cryopreserved.
Counsel, thank you. We have read the briefs. My question to you is there some interpretation of these facts where maybe there was medical malpractice at some point, but that stopped and then turned it into negligence, or was it negligence all the way through?
So it's not, look, we lost to Dr. Oktay, the physician. I haven't appealed that. I've appealed as to the non-doctors. Their treatment was not medical malpractice. So if we're talking about the statute of limitations, I don't think that it, under the standard being substantially related to medical care, that this is substantially related to medical care.
But doesn't it stem from the medical care? It's not as if this plaintiff brought these eggs to this facility for storage or on her own accord. There was a procedure, a medical procedure that started this entire chain of events, which is why I asked the question.
Sure.
Is there at some point that it switches from, because I understand what with the doctor who did the retrieval, but at some point, did it switch over to just negligence?
Well, the people at CHR, the ones we've sued, Dr. Zhang, Dr. Lee, they're not medical doctors. They're not providing medical care. So it switched over, sure, to a negligence standard at that point. But as long as we're going straight to statute of limitations, the more important issue, I guess, is even if you regard it somehow as being medical treatment that's going on, there's no question that there's continuous treatment here.
The continuous treatment, counsel, is in the manner in which the embryos were stored?
No, the continuous treatment is, so the treatment, after removing the eggs, is creating the embryos, then cryopreserving them and maintaining them for the next 2+ years.
That's
So
what I
it's
mean.
not, yes, but not just the manner in which it is stored. It is the fact that it is stored in their entire control and possession that entire time while they're monitoring the tanks.
So you view the fertilized eggs and the patient, the mother, Ms. Bledsoe, as one unit?
No, I don't. I don't view them as one unit at all. I view the patient as having been, her treatment ended when the eggs are retrieved. That's why when Judge Pitt Burke asked me if it changed from medical treatment to non-medical treatment, yes. When you're creating the embryos, that's not medical treatment. When you're cryopreserving the embryos, that's not medical treatment. The question under the standard under Wiener is it substantially related? I don't think so, because the next treatment that was going to happen was on a whole different patient 2 years later.
Right, because the way we look at it is this, we're a statute of limitations problem. If you have it as negligence, your action is timely, right? Because this accrues on the day that you provide the embryos. So it's timely in that. If we look at it as a medical malpractice, you're untimely unless you can get the continuous treatment doctrine applied.
Right,
Then it would be timely.
and to pose the question rhetorically, if I may, how could it possibly not be continuous treatment when they create the embryo, they cryogenically preserve the embryo, they put it into tanks, they have possession of the embryo, and they monitor it checking the tanks for 2 years and it doesn't leave their possession until 2 years later. How could that, how could that not be?
So which one are you arguing?
Yeah, negligence or,
I'm very confused because on the one hand, you say that you're viewing the fertilized eggs as something separate from the, what are we going to call her?
treatment from the medical
From
treatment.
the plaintiff.
Right.
I was going to use the word mother, but I'm going to use I'll use the word plaintiff.
Yes.
Okay.
mean,
You're
yeah.
saying it's, that they're separate, and then, so if we were to say that this was a medical malpractice, but they're separate, then do the eggs have standing on their own? They don't have standing on their own necessarily. You walk into all this forest of questions when you create a dichotomy between the plaintiff and her fertilized eggs.
I'm not trying to engage in any kind of philosophical discussion or theological for that matter. In my mind, this is negligence because the medical treatment ended after the retrieval.
So that's your argument, that this is a straight-up negligence claim. It may have started out as a med mal, but it ended up as a negligence claim, which has us to 3-year statute of limitations. So you don't even need the continuous treatment, right? You don't need that.
I only need the continuous treatment
If we decide, if we take the
you-
position
if
that
you-
it is
yes.
med mal.
So
That's
your-
correct.
Your adversary says that the care or of the fertilized eggs is akin to the storage of medical records. Do you agree with that?
No, I don't agree with that.
Why not?
Because it's tissue, it's not paper. And when I say tissue, I mean human cells. They're not
Yes.
born yet, but this is
Actually, you know, if you
getting
were to-
philosophical. I didn't mean to do that.
Counsel, if you were actually to agree with that, that would really bolster your argument that it's simple negligence. Because, I mean, not to say the embryos are like paper, but that's almost as you were arguing that the medical malpractice started and ended upon the creation of the embryos to put in the storage, right, into the cryo, however we talk about it, right, freeze them. So that if they take the position that it's akin to, medical records and everything, yeah, okay, if you want to take that position, then straight up, it's a negligence claim then.
I just find it a little bit distasteful.
Yeah, I totally agree with you. I'm just making that sort of observation. I'm not disagreeing with you there.
Look, all I'm saying is on this issue of statute of limitations, I think it's negligence because it's not substantially related. But if somehow somebody were to find that it is medical treatment, then by necessity, by definition at that point, it has to be continuous because it went on for more than 2 years. This case was filed 6, 7, 8 months after they got it out.
Was there the fact that in order to maybe support your negligence claim, you would need to provide some sort of expert opinion, maybe medical expert opinion, does that maybe work against you in having it be brought into? And I'm looking at the case of BF versus Reproductive Medicine Associations out of this department in 2015, where it kind of alluded that was one of the determinant factors as to why it wasn't a negligence claim, but more so medical malpractice. How do you respond to that?
So in Rodriguez v. Sal, which I cited in my brief, 4383rd, 272, this court specifically rejected the notion that it's medical malpractice just because you need expert testimony from physicians. Here, you don't even need it from physicians.
I'm trying to work this out and use an analogy of a transfusion. Just bear with me for a moment. Here you had extracting, retrieval of the eggs from the plaintiff, appropriate storage or inappropriate storage, and eventually thawing and what would have been impregnation in a surrogate carrier and hopefully a pregnancy. That's a process, IVF. And in that process, it's all linked to what the mother was seeking, to have a child.
Yes?
Blood transfusions were from one person, how it's stored, typing, eventually getting into another person. We would view that as medical malpractice, correct? That whole process.
Well, those cases do exist, yeah, that have reached that conclusion. Then you have the egg donor cases that,
So if you're right, that it's negligence, you see, you sort of like cut it. You cut it, you've ended it after the retrieval with Dr. Okay. That's one component. Then you have the embryo specialists that deal with grading, freezing, and your expert focuses on the nature of how they were frozen, the crystallization, and all that other stuff that arguably degraded a number of the eggs, that whole process. That was a key part of the plaintiff's expert position here in that component, correct?
yes?
So you're viewing that part as negligence, right?
Well, yeah, I mean, so, look, they cite a case, Annunziati, I think it's
So
called.
it's like a hybrid. It's like you're splitting the baby here.
Right, but, okay, so the difference can be evaluated by the case that they cited,
Nunziato is-
the Annunziata case
That's
against.
distinguishable. Nunziato is like a pap smear situation.
Yeah, it's a pap smear, and there's a live patient.
There's a live patient and it
whose life, depends on a proper thing, okay? Here you don't have that.
And
It's left one patient and is getting to get implanted in another patient 2 years later.
And I was listening to my colleagues' the analogy to that transfusion, but with the transfusion, it doesn't end. There's no end point, because when you take the blood to store it, I mean, you've tested the blood, you made sure that blood is good, it's clean, and that you can use it as transfusion. So that just continues to carry through all the way through, which is, I guess, in a sense, that's medical malpractice, because nothing has changed with respect to that. It's the initial point of making sure that that blood is good, and you're now storing it, and it continues to say it's good. Whereas here, you're arguing, once the embryos were frozen, that was it in terms of the med mal. We're not claiming that the removal or the preparation of those embryos, we're not arguing that that's our claim. We're saying that something happened once that there is a, like you said, there's a cutoff there. It stops. Now it becomes purely storage of the embryos.
Well, it's negligence by a non-medical embryologist
Right.
in freezing it. That's what the real claim is,
Right.
the process of freezing it, and then storage after that.
Which
But
is
it's really
different
the
from
process.
right, because you're saying there's an actual point where it gets cut off. In your scenario, that's what you're arguing. It went from medical to non-medical, whereas I think for transfusions, it just continues all the way through. There's no real demarcation, right?
Yes, I agree with that.
Okay, thank you.
Nobody wants to know about the merits of the underlying case.
Well, you could get down on
Okay, thanks.
reply, on rebuttal, thank you.
May it please the court, my name is Dan Ratner. So our position on this is that the embryologists, who by the way both had medical degrees, they're both doctors. The embryologists are working hand in hand with Dr. Akhtar, the doctor who actually extracted the eggs. He's literally on the other side of a window and saying, here, and she's calling out, here are the eggs, and then she puts them under a microscope.
Yeah, but their claim is not that. Their claim, at least, correct me if I'm wrong, they're not claiming that process, there was something wrong with that.
Oh, I disagree, Your Honor. The claim, as part of their claim, is that they were not graded properly.
Yeah,
That the quality of those eggs were not described accurately.
But the
That's a
doctor
medical-
himself, I'm sorry, but the doctor himself didn't do the grading. It was the embryologist that did the grading.
Exactly right. That's the claim against my client, who's working hand in hand with the physician who's now out of this case. That is correct. My client is handed the eggs.
That goes back to the transfusion type of analogy now. It
Right.
was
So he's-
bad to begin with, going
He's
straight
using her,
through.
he and she they're using their medical degrees, their expertise to actually assess the quality of these embryos and put a number on them. Because that, of course, is what plaintiff is arguing on this appeal, which is that if they had been graded properly, then the plaintiff would have known maybe she needed to have another egg retrieval, give it another chance, because she was misled, because they were not graded properly. Now, yes, the way they were stored seems to be part of this case as well, I admit that, but it starts with how they were graded, how they were put into a tube, how they were then stored, and I guess transported was in this case, is no longer in this case, apparently. That's medical. That bears a substantial relationship to medical care. That's medical.
Then how do you answer your friend's point that assuming it is medical malpractice, there wasn't a clearly contemplated, wasn't just contemplated, it was a necessary component that there be continuing monitoring and preservation of the embryos?
Well, thank you for asking me that question, because here's the thing. In continuous treatment, this has sort of evolved, if you will. It went from continuous treatment of a condition to monitoring is equated with continuous treatment in the case law over the last 20, 25 years. So now, in my view, we're extending it even further out. There's no condition that's being monitored. There's no contact with the patient after the eggs are retrieved and stored. They're just being stored. Now, I didn't mean to sound glib when I was equating it to a medical record, Your Honor. If you look at my brief, what I said was it's like storing medical records, radiology films, tissue samples. All of those things are stored by medical treaters.
But the issue with embryos is that if they're viable, they're capable of transmitting life. And that's the part, I guess that's the question that we're asking with respect to treatments. They have to be monitored, they have to be observed. There was testimony that they were observed twice a week, I believe, or monitored twice a week. And they were being monitored so that they could be actually kept alive. You know, you don't have to keep medical records alive, you don't have to keep films alive, but you have to keep the eggs alive, otherwise they're not, the embryos alive, otherwise they're not viable at the point where they're removed from
I have no quarrel with anything you just said in terms of distinguishing between a medical record, if you will, and this type of what's going on here. I have no problem with that. The problem I have, though, is where is the condition that's being monitored? Let me give you a great example.
Let
There are a lot of cases.
let me follow up on something that just came to mind in light of Justice Gonzalez's question. Take the following hypothetical. You have a live-born human being who's in a hospital, who's on life support, and is being monitored by the hospital. How is that different from the embryos in their state being monitored in an effort to preserve?
I love that example.
blocks of life?
That's a great example because the person that you just described has a underlying condition. They don't know exactly what it is, but they have a condition. They know they need to monitor it. Fibrocystic disease, perfect example. A lot of cases.
Is that the example you're going to use?
Yes.
Okay.
Breast cancer cases. The doctor diagnoses fibrocystic disease, monitors it for years, and then later on, there's a claim of a failure to diagnose breast cancer. Those cases have held that's monitoring of a condition, even though it wasn't the same condition that was not diagnosed. For obvious reasons, they found something, they need to keep an eye on it. Here, this is much closer to storage. There's nothing going on. There's no contact with the patient whatsoever.
Well, then, counsel, I don't know how you can have it both ways, making that particular argument, saying that it's much closer to storage, there's no other contact with the patient, and then not say that that's at the point where negligence begins.
Well, I go back to I see my time is up. Can I just answer your question? I would just go back to my point that if it bears a substantial relationship to medical treatment, and this is where it started, they were evaluating, they were removing, grading, and then storing. It can't go from one to the other. This is not a situation where you have a blood bank, let's say, far removed from the patient care. This is a known plaintiff who was under their care medically.
Because it's basically how they allege their claim, how the claim is being presented. It's not just simple split. It's not compartmentalized. On the one hand, it's medical, and then on the other hand, it goes to non-medical. It's not. It's according to what you're saying, part of the claim is the storage, but it really starts from the retrieval of the embryos, the grading, and everything.
You don't have to look any further than plaintiff's own expert affidavit, where the expert goes on and on and on about how they were retrieved and how they were graded, what advice the patient was given. It says nothing about the storage. He later says, well, there may have been a breakdown somewhere along the line, but it was all about how our embryologists did their job, not whether the tanks failed.
So I'm going, if I may.
Yeah.
So I'm going to invent a term and hopefully not be offensive in using it. So using the example that my colleague just gave about a person who perhaps is in a coma and has to be monitored, or yeah, let's say that, all right. And looking at the embryos, is there a distinction between medical storage and storage? I'm making up the term medical storage. I'm looking at the doctrine of continuous treatment and saying, does this have to be extended in some way? Questions?
I don't know exactly how to answer that question, except to say, I think we've gone so far afield of the continuous treatment doctrine in even having this discussion, because there's no underlying condition. The whole point of continuous treatment was a doctor makes a mistake, or may or may not have made a mistake, knows or should have known it, and then, the patient wants to go back to that doctor. Don't interrupt care, so you can, because then you might have to, by suing the person, keep going to that doctor.
No, make
but
it
that's what
simpler. Make it simpler.
Not a corrective
There's no
effort.
mistake. There's no mistake. A patient is in a coma and nobody knows why. The doctors are really smart, but none of them know what it is. You got to keep the person alive.
Right.
That's it.
And if,
No
if at
mistakes.
that moment in time the plaintiff thought my doctor committed negligence, I better go see somebody else.
No.
That's not what we want.
And if during the time that the person is in a coma, something happens where their storage, again, I don't mean to be crass.
I know.
But I don't know how to say it in another way. Their storage is not properly monitored and maintained, and they have a problem subsequently. Is there a distinction between that and the embryos?
Yeah, I agree that if a patient is in a coma, the doctor should continue to care for that patient, and the plaintiff should not have to, have a worry about a statute of limitations. Continuous treatment should apply. Here, there's nothing like that. There's no condition. There's no corrective efforts to treat a condition. Nothing that, all the normal principles for continuous treatment don't apply in a situation like this one.
Okay, thank you.
Thank you, Your Honors.
Listen to what he's saying. He's saying on the one hand, it's not medical treatment, but on the other hand, he's saying on the one hand, it's medical treatment, okay? But on the other hand, there's no condition being treated. Therefore, you can't have continuous treatment. It's like Judge Pittsburgh said, you cannot have it both ways. It's got to be one or the other. In this circumstance, it can't be both. It's kind of like the coma patient who's in the hospital. These embryos are in their possession and control. If it went 3 years instead of 2 years, if it went 3.5 years instead of 2 years, by the time they found out there was negligence, the statute's gone. Okay, now that pertains to a discovery rule, but that also pertains to continuous treatment, because continuous treatment talks about an ongoing relationship of trust and confidence. That trust and confidence was had by Ms. Bledsoe and Mr. McKee when they entrusted these embryos to be cryogenically preserved and maintained until they needed that, and it went on for over 2 years.
So, counsel, quickly tell us whether or not the merits. Let's get to the merits quickly that you mentioned at the end you want. So tell us
Sure.
why you think
Okay.
you have a meritorious claim.
9 embryos frozen. When they're thawed, 2 are missing altogether. 2 more are totally unrecognizable, and a 5th one is only 3 cells and not viable and should never have been saved. Their chances of success were cut in half by that alone. Then you have whether or not they established their entitlement to summary judgment. They're experts. All Dr. Matera, the only physician, by the way, is talking about the embryologist being a medical doctor. They're expert. Dr. Adler, the embryologist, is not a medical doctor. That's because embryologists generally are not medical doctors. They don't perform medical care. Okay, but Dr. Matera, all she talks about is plaintiff only had, because she's 40 years old, an 11% chance of success. Therefore, it didn't matter. In addition to being immoral, it's legally erroneous. The Roser case, as well as the Stewart case, both establish even a 5% chance loss of that is actionable. The next issue is the negligence. They put in experts who basically come in and say, well, this can happen for no reason or any reason, but they don't identify those reasons. Dr. Matera says it could be poor embryo quality, but they were rated as fair and good, not poor. So they're giving you a conclusory assertion of no reason at all. Basically, stuff happens is what they're saying, okay? In the meantime, the defendants themselves, Dr. Gleischer, the director, Dr. Lee, the lab director and Dr. Zong, the embryologist who did this, all say you cannot have degradation or deterioration or any change if it's properly cryopreserved. They don't address that in their expert affidavits. The expert affidavits were conclusory and contradicted.
Just one final point for me.
Yes, Judge.
We have the Annunziata case out of the Second Department that talked about laboratory services being at a physician's orders being medical services or medical malpractice. So in that case, if the whole process, and that's what Justice Swank was raising with your friend, that it's one long process. That's why I use the transfusion analogy, that if it's one long process, for you to be able to succeed under the statute of limitations, it has to be continuing treatment. You view that whole process from retrieval all the way to the very end till it's thawed Yale to be continuous treatment, correct?
If it's viewed as substantially, now Annunziata is the case with the pap smear, which we.
Well, I said the lab services, right.
But if it's viewed as substantially related to medical treatment, then Dan said
Well,
there's
the
no
medical-
condition.
Sir, the medical treatment being
Being-
IVF. She's
IVF and the creation of embryos and cryogenically preserving them. That is the condition being treated, and it, by definition, is an ongoing process at least till they remove it. It's in their possession and control. How could the statute of limitations possibly not be told while it's in their possession and control?
So you're saying now that the eggs, the embryos are not separate and apart from the mother, that they're one and the same? Didn't you say before that they were separate?
What I said was I'm assiduously trying to avoid theological and
Oh,
philosophical.
sorry.
Let's got enough problems here, what we have in front of us. Okay, thank you. We-
apologize, I
We
couldn't
got it.
answer
Thank
that
you very much.
adequately,
Thank you.
Judge.
Very good argument. Thank you very much.
Thank you.
Okay. All right. People versus Darling Alba. Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Mark Zeno, and I represent Appellant Darling Alba. On the question of whether the people proved that Mr. Alba intended to commit a crime in the building, I defer to the videotape, which if you haven't watched it already, I ask you to look at it. We can disagree about characterizations about how hard Mr. Alba tried to get through the window, but the video really speaks for itself, and I don't intend to dwell on that point.
So your focus on appeal is really the waiver of the right
Yes.
to be able to listen to the voir dire?
Yes. Yes, so let me turn to that. The court erred when it refused Mr. Alba's attempt to rescind his antimarchy waiver before a single juror was questioned. Here the record shows that Mr. Alba waived his right to be present at sidebar conferences, believing, as his attorney explained to him, that those conferences would only occur when the jurors wanted to speak privately. The court told Mr. Alba that twice, that when the jurors wanted to speak privately, he had a right to be there, but he could waive that right. Yet,
The issue really here isn't the waiver itself, because it's what happened afterwards, right? So when counsel said things such as, my client should hear this, or prefer that it be said out loud, did that constitute a specific request for relief? And if so, what relief was it? Because, I mean, it didn't really say anything after that.
right, well, he didn't really say anything after that because the court denied whatever he was asking for by saying you waived antimarchy. So yes, the issue here is about the rescission of the waiver. It's not about the waiver itself. And counsel certainly could have been more precise in his request, but he made clear.
So do we have a preservation issue here?
Well, yeah, there is, obviously, we're arguing about preservation. The people say it's unpreserved.
Because he says, quote, I mean, I have in my notes here, there are so many, I prefer they say it out loud. I mean, what does that mean?
Well, what could it mean except that my client had a right to hear it?
Well, then, but the court then said you waived Antomarchi, and he didn't respond, and there was no further discussion. So it's like, it's an empty record for us to even understand where counsel's arguments would be
Well,
coming
I
from.
think we all know what he was talking about. I
Well,
mean,
I don't know. If I knew that, I'd think the next number is Lotto, but that's not the case. Yeah, I mean,
I'm not sure how to respond to that.
yeah, well,
The lawyer said, when the court said, line up and come to the bench and talk to me,
yeah.
the lawyer said, are you doing it here? Obviously surprised that the court was conducting those conversations at the bench and not in the open courtroom in the presence of his client. He then said, my client should hear. What does that mean, except my client has a right to hear the answers to these questions?
Isn't the fact that you're asking us to surmise what was meant a problem?
It's a problem in that if this court finds that it's not clear, it is a problem. But what could that have meant but for my client has a right to hear
We're
this?
familiar with I object or I reserve my rights, my client's rights. We're all familiar with that.
But the court's response to that is, this is what antimarchy is. You waived antimarchy.
One of your arguments is at that point, the court maybe should have detailed the reasons why, so that we, as the court, would know whether or not it was an abuse of discretion. Is that correct?
Right, correct. The court understood that he was asking to hear what antimarchy guaranteed him, but he had just waived. The court understood this was an antimarchy problem.
It sounds like we have a 440 situation here, right? I mean, if you want to know what the attorney was thinking, what was actually going on, I mean, I don't know, it's just a blank record in front of, at least for me, that I can't.
The court, in its response to the objection, the lawyer was actually asking for something, right? We know the lawyer was asking for his client to hear what was going on at the bench, right? That much is clear. We can disagree about whether it's a rescission of antimarchy or not. We know the lawyer was asking that his clients had a right to hear what was happening at the bench. And the court ruled, no, that's antimarchy, you waived it. So what is the need for what more could have been said?
I object.
I object. He did object. He said he asked for a remedy. The purpose of an objection is to ask for relief.
Once the court, like my colleague is pointing out, once the court made its decision, defense counsel is going to say, I object, right? I object. And that would have been, for us, that would have been very
470.05 specifically rejects the idea that you need to take exception to a ruling. The court ruled. That's all that the statute required him to do.
Okay, thank you.
May it please the court, my name is Alice Wiseman, appearing on behalf of respondent.
Counsel, just picking up from that particular point where in the court's response, they didn't really say anything as to maybe address the issue at hand as to whether or not the court understand that, in fact, defendant wanted to now rescind his antimarchy. He wanted to be present for everything. He changed his mind. But the court, in its brief response, didn't really detail anything other than, one comment. Are we in a position to address that at this point?
Well, Your Honor, I don't think the court actually did make I think what the court's questions were simply, or the court's statements were simply basically being in the same position this court is, trying to understand what is the defense attorney talking about, because he doesn't say my client wants to rescind his waiver. He doesn't say my client wants to be present. He just says, I would prefer, there's so many of them, I would prefer that he hear it. Now, at that point, the judge, trying to understand what's being asked, says, well, but that's antimarchy. You waived antimarchy. At that point, the defendant, that's not a ruling. I mean, the defense could simply say, yes, but he wants to, or I want to rescind that waiver. The judge is never presented with the issue of...
But I mean, obviously, we can read the record. I mean, he wanted something, right? And it's in reference to antimarchy and what's in the fact I prefer it be said out loud and my client should hear. What else could we interpret that to mean?
Well, I think the defense attorney, apparently about 20 people gotten lined up, and bear in mind, almost every single one of those, or the majority of those people were talking about things that the defendant had no right to be present for anyway, because of course, defendant does not have a right to be present when the jurors are discussing scheduling issues, which is what most of them had. So, you know, the judge understands that we have a lot of people here, we don't know what they're asking. I think he is simply trying to find out what does the defense attorney want. I think the defense attorney was, you know, whether we just impulsively said something and then when reminded, well, yes, but Antimarchy's been waived, he was silent. There's no way, I think, that you can say from that certainly that he's preserved any claim
I would
here.
think the record seems to suggest that the sheer number of prospective jurors kind of caught the defense counsel off guard. I mean, that's what, it seems like that's what happened here. I mean, he didn't know that 20 prospective jurors would raise their hand and say, oh, no, I have an issue, right? I mean, that's the sense of it.
I mean, that's the way I read it. I think, bearing in mind, again, at that point, they didn't know even how many of those would even be jurors to whom the Antimarchy waiver applies. And indeed, most of them were jurors to whom the defendant had no right to be present anyway. Had there not been an Antimarchy waiver, presumably the judge would have divided, you know, who lines up here. Let's have the people line up with scheduling issues where the defendant doesn't have a right to be present, and then we'll do the Antimarchy thing separately. So I think the defense attorney has got to present this to the trial court and make him aware that he's asking for a ruling. Beyond that, though, I would just say, I think in answer to your question, Justice Piper, no, the judge doesn't explain. If we assume that what the judge is doing, and I don't think he is denying a request to rescind, obviously he has no reason to explain why he's doing it, but it could not have been an abuse of discretion to do so here, because if we look at what has happened and compare this to the Court of Appeals case of Williams, where they said it's not an abuse of discretion to rescind, in that case they'd had a single roving room conference, and then the defendant, and this time that they did explicitly say, I want to rescind my Antimarchy waiver and be present, and the judge said, I don't want you going back and forth, and so he denied it. Here, yes, the judge didn't say that, and they had to question somebody, but they've got 20 people lining up. They have the defense attorney saying something ambiguous, which presumably, since the defendant had personally waived this right, you'd have to consult him and make sure it's what he wanted. And that would be just as disruptive, and again, given that we have so many different categories of people, it creates the possibility that he wants to be present for some, not present for others. It's exactly the sort of thing where the court is within its discretion to say, no, that, you know, I control this courtroom, this is going to disrupt voir dire. Again, I don't think we get to that because there simply was no request, and there's certainly no reason, you know, it's unpreserved. It also just, there was no request to rule on. Now he's been convicted on what I submit as overwhelming evidence. Again,
What is your position on the actual crime? Your adversary came right out of the box saying the guy was just simply trying to warm up and not really trying to commit a burglary.
I think, again, like my adversary, I invite you to look at these videotapes. It's very clear. It's 3:30 in the morning. These two young men, they make their way through a locked gate. They look around, you know, examining everything, clearly coming to take whatever they can find. They even remove a couple of things. Then he goes to the window of a clearly occupied apartment. He peers in. He gets some object he tries to open. They actually run away and then come back. He tries to open again. This is not consistent with anything other, you know, as we discussed in our brief, anything other than the intent to commit a crime inside there. And conversely, unlike the cases cited in defendant's brief, absolutely nothing in the record other than one witness agreeing, yes, it was cold out.
Counsel,
Nothing.
with respect to the Williams case, in that case, the defendant waived his right to be present in the roving room during jury, queries of the jury. Okay, and so here we have something similar, but then there's an apparent change of heart by defense counsel. With Williams, the similarity that I would see is that there was no elaboration by defense counsel as to the reason why there was a waiver. How would you distinguish Williams from this? Or how would you say that it's the same?
Well, I would not distinguish it. I think it is the same in that in both cases, you have a valid waiver. One thing that distinguishes it is in that in Williams, the defense attorney was clear. My client wants to rescind his waiver and be present. That didn't happen here. Here, again, the defense attorney is saying, well, I prefer they hear it. You know, that's just, I think, again, just a spontaneous reaction. And once he was reminded of the Antimarchy waiver, he backed off. So that's a big distinction. But again, even in Williams, the Court of Appeals said it's not an abuse of discretion to not let him rescind that waiver. And apparently simply because of the concern that you can't go back and forth once we've started. And here, I'm sorry, Judge.
And do you agree that or disagree that a defendant can rescind an antimarchy waiver?
Absolutely. I mean, there's no bar to rescinding it, but it's within the discretion of the trial court. The trial court does have discretion, and that's what Williams says, and what this court, I think, also said in Evans, can deny that attempted rescission.
That's provided that there's a sufficient record to determine whether or not it was an abuse of discretion, right? Not just one sentence from the judge.
Well, again, I don't believe the judge here was ruling on any such request, and I think...
No, I correct me wrong, but I think the question is, I don't think there was a trick question. It was just that provided there's a record for the judge to make that determination to deny the request to rescind. I mean,
Of course.
we don't have that,
Right.
at least in this record, we don't seem to have that.
No, although I do think if you look at the situation here, it is reasonable. The trial court doesn't express its motivation because, again, I don't think it's doing anything, but it certainly is reasonable if the trial court had said, just like the judge in Williams, no, I'm not going to let you flip-flop, that would not be an abuse of discretion. And that's all the trial judge said in Williams.
Thank you.
Thank you.
2 points about Williams. Williams was decided by the Court of Appeals, obviously, which operates under an abuse of discretion as a matter of law standard. This court has the power to substitute its own discretion. This court has more power in that regard. That's number one, and Williams is very distinguishable. Here, my client's lawyer changed his mind before a single juror answered a single question. There was no danger of flip-flopping. Once the lawyer realized that jury selection was not going to happen as he understood it, and different parts conduct jury selection in different ways, here the court was going to be inviting large numbers of jurors to the bench to talk about matters, some of which my client had a right to hear about. Once he learned it was going to be conducted that way, he asked for his client to be able to hear the answers of the jurors. That's a right that he had he not waived it. Obviously, the lawyer was laboring under an understanding that that questioning wouldn't be conducted at the bench, told his client that, and that's why his client waived, and merely wanted to go back to square one. And there was nothing to lose at that point.
Thank you, counsel.
Thank you.
Harriet Tubman Garden versus Bluestone. First person up, York Restoration.
Good afternoon. Fern Flomenheft for York Restoration. May it please the court? The Supreme Court erred in denying York's motion for summary judgment in its 9/14/21 order and its 10/11/22 order. It's undisputed that York's work was solely pursuant to a contract with Kahane, that its work was approved and signed off on by Kahane, and neither the plaintiff's expert nor any other party or any party has identified any defects in York's workmanship. The court's...
So understanding that there was a sign-off, so to speak, by the architect saying that the work can be done satisfactorily by York, was York authorized to go beyond the scope of its contract?
No, York had no discretion, no authority.
I didn't finish my question.
Oh, I'm sorry, I thought you had. I apologize.
That's okay. Was York authorized to go beyond the scope of its contract in the event that additional defects were found, additional problems were found?
Again, no, it was not authorized to do anything more than what it was instructed to do by Kahane. And anything that it specifically stated in the contract that it had to, anything beyond the contract had to be approved by Kahane had to be instructed by Kahane.
This is a situation where your client, the best thing they did was just follow the instructions and just go straight through and don't do anything other than what they're instructed to do, right?
Well, they didn't do anything wrong, Your Honor.
No, I'm just saying, but this is
Yes.
this is one of those unusual situations that you follow the contract to the letter, and you don't say, oh, you need this, you need this, you need this. They just did what they were told and left, and they got approved by the architect. That was it.
It's that simple because that's all they were authorized
Yeah.
to do.
It's not a trick question.
No, I know. I mean,
It's a restatement of what I think I see in the record.
intuitively, one would say, you know, they're there, maybe they should pick up on something, but they were not hired to do that. They were hired to be the workers. The contract, if you read it, is so specific, I mean, in excruciating detail as to materials, as to everything that they were required to do. Kahane was on the site, as was plaintiff's architect. Lawless was on the site, doing water tests after each repair. And, you know, it's undisputed that York cannot be responsible for the original workmanship. And that's where the court, I think, really got it wrong, because the court refers to defective workmanship, citing plaintiff's expert report, and
He referred to the original construction.
he leaves out the reference to the original construction, so that it's really, I think it's just a misunderstanding or misinterpretation of the report. But I think there's only two documents that really matter in this case, and those two documents are the contract and the sign-off letter, because you know, under the law, I mean, once if York is only required to perform the specified work, and it performs the specified work and meets with the approval of whoever's supposed the contracting party, they're entitled to summary judgment. Now, the judge went beyond that, and he looked at the plaintiff's expert report. But the plaintiff's expert report is actually helpful to York, because basically the plaintiff's expert report identified three shortcomings, and one is the implemented flashing repairs at the beginning of the work.
Right.
The second is the repairs, the scope of the repairs, and the third is the use of caulking instead of mortar, and that's it. So that's all there is, and there's not going to be anything else. There are no other experts.
I mean, correct me if I'm wrong, but I didn't see any claims that your client, that York didn't follow what it was supposed to do in the contracts in terms of the kind of caulking used, in terms of what they did in terms of however to repair the leaks. I mean, they just did what they were told to do. I mean,
They did exactly
whether or not it was sufficient, that's not what York was retained to do, to determine the sufficiency of the remediation.
Correct, and it's as simple as that.
Okay. Thank you. Arthur Kahane?
May it please the court, my name is Scott Winico, and I have the pleasure of representing Cross Appellant Arthur Gatane Architects, PC. This case, the claim against my client concerns a third-party complaint.
So let me ask you, you guys were hired to, I guess, remediate the problem, and you weren't, in terms of how you went about to do this project, you didn't have your own, you weren't actually required to have your own person come in and investigate and sort of figure out what it is. You were kind of told what needed to be done. And
Correct.
This was it?
Correct.
You were like, okay.
Correct. We were not involved in the original construction. We were told the owner hired Lawless to do their own investigation. We were told these are the repairs that need to be done. We were hired to perform limited repair services only to those repairs. Lawless was
You
involved.
weren't asked, at least I didn't read the contract, where you weren't asked for your opinion as whether or not Lawless's recommendations were up to par in terms of rectifying the problem.
Correct. We were told this is what you have to do, don't deviate. And that's
You
what we did, and
were
that's what the
circumscribed
contract says.
by Bluestone, is that correct?
I'm sorry.
You were circumscribed as to the scope
Correct.
of your
Correct.
work by Bluestone, and that's reflected in the letter dated March 26th of 2007, right?
Correct. That's the contract with us in Banta. And
What's the period of time between the Lawless evaluation and the letter, the March 26th letter, the
I think-
2007 letter?
Lawless did issue 2 letters, both in 2006. We were hired in 2007. The work was completed in 2008. 3 years later, during Hurricane Irene, that's when water leaks occurred. We were never hired to repair, make this building watertight. That was not what our job was.
Between the time that Lawless did its investigation and the time that the work actually started by Kahane, is that how you pronounce it?
Yes.
There was no independent evaluation or evaluation by Lawless or by Kahane that the scope of work had not broadened?
No, the only evaluation was done by Lawless. We were told this is what Lawless's plan was to do. We were given direction. We're only supposed to be doing the work that Lawless directed, only those areas. That was it. That's what our contract says. That's what the March 26th letter that you referred to, that contract, that's specifically what it says. That's what our sole scope of work was.
And of course, you've seen the Martos report, and it talks about incomplete flashing that was never, am I saying it right? Is it Martos?
Martos's
part of
report, I mean, I've only seen it in connection with this motion. We've never deposed him. But the Martos report actually says my repair scheme was good. That's what he says. He says the repair scheme designed was good. Perhaps if Lawless had asked us to do more than what we were supposed to do, more could have been done. But we did what we were supposed to do. We followed, again, what we were directed to do, what the contract required us to do. The contract says we've been asked to prepare the March 27th letter that you're referring to. It's supplemental record 27, says you have asked us to prepare plans and specifications for the remedial work performed by Mr. Lawless's findings without conducting any additional probes. We were told not to go around and search for more work to be done. We were supposed to just rely upon Lawless's work. Again, it says under the drawings and document phase, these drawings and specifications will identify areas as relayed to us, that's relayed to us by Lawless, that are experiencing water infiltration. That was the scope of what our repair work was. Our contract is solely with Banta. We have no contractual relationship whatsoever with York, and I want to make that clear, because their claim is for breach of contract. We have no contractual relationship with them whatsoever. Our contract is solely with Banta, and again, the only other claim is the indemnification claim, and York is being sued for its own alleged wrongdoing. They're not being sued for my wrongdoing. If they did everything that they're supposed to be done, they're not going to be found liable. If they are found liable, it's because they did something wrong. There's no right to indemnification under those circumstances.
All right, thank you.
Thank you, Your Honors.
Respondent Harriet Tubman Gardens.
May it please the court, Michael Hatchett for the respondent Harriet Tubman. I think I would focus in on, based on your questions, of where our claim is. Our claim lies not in whether they repaired the unrepaired or the bad work that was done in the original construction. We're talking about the repair work they did. They provided a warranty to Banta, which then came to us because we were made a part of the contract that York had with Banta. Specifically made a part of that contract, and we specifically got a warranty on workmanship and material use.
Right.
I would point out,
Counsel.
Sorry, go ahead.
I got a question. But the way I look at it is that the work that York did got signed off on by the architect, and then the architect's work was signed off by somebody else saying that it was fine. The question is that, well, not the question, but then the architect, I heard an argument in the record here, says that they relied on Robert Lawless's investigation, right, in terms of what needed to be done. So maybe I missed it, but was there an affidavit from Robert Lawless as to exactly what the conversations went on in terms of what needed to be done for this project?
The design, the remedial design, was made by Kahane.
Right, but
all Lawless did was look at the building and find areas where he thought there needed to be repair. The actual design of the repair, the remedial design, was a design put forth by...
And who had to give approval of that design?
Banta. Not, the owner was not, did not
So
have to
if
say.
Banta had to approve what Kahane did, why is Kahane on libel then? Because if Banta is the one.
We're not suing Kahane. We're only suing Bluestone and Banta and York.
I know, they're all
who-
third party
Who
then.
actually did the work, right? And our claim is that the work, not the remedial plan, the work that was done in furtherance of the remedial plan was not done appropriately. And
So-
we believe that is what our,
So,
part of what our
counsel,
expert report says. Sorry.
You're not referring to the caulking versus mortar issue, right?
We are in fact talking about that issue because if you look at Kahane's brief, particularly on page 8, they claim they never directed York to use caulking, that was not a part of their plan. And that is one of the serious issues of repair that is enunciated in the experts
So
report.
that's separate and apart from the incomplete evaluation or incomplete scope of work that's also an issue here, right? As to York.
Yeah, we can see that York did not plan the scope of remediation. We're only talking about the work that York did in furtherance of the remediation.
And it's your argument that York elected to use caulking instead of mortar?
It's our contention that Arthur Kahane's brief, they say they did not direct the use of caulking, and caulking was one of the serious issues
And in
found.
reliance on that, you maintain that York is therefore liable for caulking?
York gave us a warranty. It warranted both workmanship and material. So caulking is a material, so presumably.
Well, that's your direct claim against York, is that the material you used is no good. So
Correct.
You got to warranty it, right?
Correct. That either, if the workmanship was poor or the material was poor, we have a claim.
Right. I get it. Okay. Thank you.
Thank you.
Bluestone.
May it please the court, my name is Michael White, and I represent the respondent Bluestone.
So, counsel, the letter between Kahane and Bluestone dated March 26, 2007 is, in my view, most unusual because, as I'm quoting from the letter, you asked us to prepare plans and specifications to remediate work pursuant to Mr. Lawless's findings without conducting any additional probes. So the condition precedent for their doing any work was Mr. Lawless's evaluation. How do you get around liability in this?
I believe that letter was with Banta, not Bluestone. The Bluestone organization is separate from Banta. And Lawless was hired by the building, Harriet Tubman Gardens. So
Banta is allegedly one of your affiliates, yes?
Banta it's a separate company. It's Bluestone organization is a completely separate company than Banta Homes.
And it's one of your affiliates?
It is an affiliate company, yes. And then, but what we are opposing is York's motion, and York's motion says that they didn't do anything wrong, but the plaintiff's expert report says that they used caulk in the weep holes, and that prevented water from coming out of the building. So the water was trapped behind and is causing the damage. So our claim is separate, that York did something wrong.
So it goes to what my colleague was referring to before, the materials?
Yes, and York entered into a contract where they said that they would do the work in a professional and workmanlike manner. In addition, there's an indemnification clause where they have to indemnify Harriet Tubman Gardens, Banta, and Bluestone with respect to any damage caused arising out of their work. And according to plaintiff's own expert, the installation of the caulk is blocking the weep holes, and that's preventing water from coming out, and that's causing the damage. So we have a contractual indemnification claim against York, and it's clear that it arises out of their work because it's caused by the caulk that they installed and that Arthur Kahane said should not have been installed.
Got it. Thank you. Okay,
Thank you.
thank you.
I have a few things to do here, so,
So, yeah,
first of all,
hold on a second. Now, having heard the arguments here, I don't know, the way I'm listening to it is they're not really arguing, at least maybe I'm wrong, they're not arguing that you didn't follow the letter of your contract with Kahane. The two arguments that I hear is, one, the caulking that you use was not good, and that's where the 5-year warranty is coming out of. And the second argument from Bluestone is like, yeah, and they also caulk the weeping hose, which I know what that means, because if you caulk weeping hose, the water's got to go somewhere because the weeping hose are for the waters to drain. That they're saying. They're saying the caulk you used and the caulking process you did were defective. That's not saying that you didn't listen or follow or did anything incorrect with respect to what the architect told you to do. They're saying that what you actually did was not good.
well, they're saying that, but Kahane didn't say that. Kahane, and if you look at the,
Yeah, the Kahane approved what you did, correct?
Kahane not only approved what we did, but if you look at the contract and the specifications, very clearly it addresses the materials that were to be used, and Kahane had to inspect the caulking, and they did inspect the caulking, and there was nothing wrong with the materials used. Everything that was
But
used.
stop 1 second, counsel. Who decided that caulking would be used as opposed to mortar?
Well, it's in our contract and Kahane essentially hired York.
Right.
Kahane contracted
Is there a
with.
contract from
There's a,
Kahane?
Kahane has a contract with Banta.
Right. And Banta hired
And Banta hired York.
Right.
Okay, so Kahane did not
Well,
hire you.
wait, I'll explain.
Okay.
Kahane's contract with Banta provides that Kahane will supervise the contractor. Kahane issued the specs to York, which are specifically referenced in York's contract as being the specifications that will govern the job. So in other words, Kahane, and then
I mean,
Kahane-
regardless of what that says, there's a big issue here that Kahane signed off on the work ultimately, whether or not they were liable, supposed to do that based upon an agreement with you or some other contract, but they signed off on your work saying it was all good to go.
Well, ultimately, that's right, but what's being misrepresented here is that the Kahane did specify the materials, and there's an extensive.
I don't think, my point was not about the materials itself. My point, I guess it is. I mean, the caulking that you use is one argument is it's not good caulking, and the other argument was that the caulking itself was not done properly. So I guess you're right, it is. But you're saying that we use exactly what the architect told us to use.
It's just false.
How else can we?
I mean, it's just false. Pages 263 to 271 of the record extensively details these. It's Exhibit B to the York Banta subcontract.
I get what you're saying.
Is the specs issued by Kahane.
Right, I
in
get
the
what you're
bidding
saying. You're saying
process.
everything that I did, the caulking I used, I did not pick my own caulking. I used the caulking the architect told me to use. And in terms of the caulking process, I got clearance from the architect saying, you're good to go, thanks, bye.
And Kahane inspected the caulking and inspected the work, and Lawless, which is Bluestone's architect, inspected the work. So this is just completely false. I know my time is up, but there's just a few more points that were raised. I mean, as for the warranty, I mean, it specifically excludes any liability of the architect. Now, you've got two architects here. You have Lawless and you have Kahane. And so York cannot be responsible to indemnify anyone arising out of their acts. If it's the materials, it's Kahane because they issued the specs. If it's the work, then it's not it's not York's work. It's what was actually the scope of the work, as the expert said. And so there can be no indemnification. It just doesn't apply. There is substantial reference to Bluestone's refusing to expand the scope of the job, so that is definitely there. So if it's not the architect, then it's Bluestone's refusal to allow the full scope of repairs. So it's got to be one or the other. Either way, they can't be indemnified for their own negligence.
Was there a different decision by another judge involving identical issues as here?
Well, Justice
In
Hegler,
Banta versus Zhao, does that involve the same complex, same?
it involved the same exact project and the same issues, yes.
And the ruling, and you sought renewal and grounded it on collateral estoppel, correct?
Yes, because Justice Hegler said there's no evidence of York's negligence. It wasn't negligent.
Okay, thank you. Oh, 1 second, counsel. Whoa, one more. You don't want to run out in the cold, just relax.
I will try to be as brief as possible, but a lot of what you just heard is totally incorrect.
If you shook your head any harder, you would have popped off your
Well,
shoulder.
again, as pointed out, there is no contractual relationship between my client and York.
Right.
There is none. We were not hired to supervise them. Nowhere in our contract was that obligation placed on us. And there's plenty of case law this issue was never even raised in the brief, but there's plenty of case law out there that holds architects don't supervise contractors' work. We're not responsible for that work. By signing off on that letter, we don't become a guarantor of the contractor's work. We're not responsible. The record shows we submitted our plans in the record. There's no caulking that's there. It's not there. This issue about Martos, his report was issued in 2008, years after the work was completed. We don't know who installed that caulk. That caulk could have been installed by others. It may not have been installed by York. It could have been installed by their own maintenance people. We don't know. Nothing in Martos's report says my client did anything wrong. He just talks about the repairs being proper. Maybe they were limited, but if they were limited, that's not my client's fault because we did what we were supposed to do. There are 2 causes of action against my client. Breach of contract that York has asserted. There is no breach of contract because there is no contract, and common law indemnification. They are sued for their own wrongdoing. And again, just to raise this point, because it's been raised in the brief, my client was pleaded into this case back in 2017. We moved to dismiss common law indemnification claims. Justice Kennedy granted that motion, dismissed all common law indemnification claims, including any potential claim that York could have asserted. York opposed that motion, never appealed it. That's the law of the case. The common law indemnification claim was already dismissed. We shouldn't even be here discussing that point.
Okay, thank you.
Thank you, Your Honors.
Georgetown Company versus IAC Interactive.
Good afternoon, Your Honors. Thank you very much. Georgetown only has a claim here if it can establish that IAC obtained a right to purchase the property.
Yeah, whether or not the related transaction falls within that letter agreement provisions, right? I mean, is essentially it, correct?
Well, that's
that's what they want. The $35 million that you got, that's what they want, a piece of it, right?
Exactly, Your Honor.
And the only way they can get a piece of it is if it falls into the letter agreement provisions, right?
Exactly.
All right, so let me ask you this question then. It looks like ostensibly that you didn't buy anything and you didn't lease anything, right? You got $35 million because of the FAR rights that the city council, the legislation changed to increase the FAR rights, that the owner, Reliance, right, now wants like these 4 lots of really valuable now because they got more FAR rights. But isn't those FAR rights conditioned on HTRF making a contribution to the Highline Fund? Like it wasn't automatic?
Well, absolutely, it wasn't automatic.
So that in terms of the $35 million coming out, but there is money going, in terms of $35 million coming in to the defendants, there's also money going out to actually make this, to make what the legislation did. It was inchoate until that contribution was made. Once that contribution was made, then you lock down the FAR rights. Is that what happened?
Maybe I can try to help parse through.
Yeah.
I 100% agree with your initial statement of whether the issue here is whether the related transaction triggers, right? Yep. They've essentially, however, just so we're clear, they've essentially walked away from that and abandoned that argument.
Okay.
Okay? They say in their brief that that's not when the letter agreement was triggered. The letter agreement was triggered before the related transaction, upon the rezoning, all of a sudden.
Yeah.
Right? Okay. So just so we're clear, and I can spend more time on it, the reason they did that, even though that was the primary theory of their complaint, is because
Well, that's the related, the reason why we have related is the $35 million. That's what we're looking at.
Well, yeah.
Okay, so they're
they
saying
want a piece of the
beforehand,
money. Okay.
which the beforehand process goes exactly
So
to what I
let's go
said
to the
about the
beforehand.
contribution part, right?
So here, who is IAC? All right? IAC is a tenant.
All right.
IAC leased.
Subtenant to HTRF or HTRF.
HTRF is IAC. HTRF is the IAC entity, right, that is leasing the land. Okay?
Which has the joint venture agreement with the plaintiff.
You got a flow chart here. You guys got a great flow chart here.
You're right. I mean, you know, there's a bunch of different contracts by sophisticated lawyers, et cetera, et cetera.
But ultimately, there was a joint venture with IAC in Georgetown 19th, and then there was the sublease to HTRF, right?
Correct.
Okay.
All right.
We've done our work.
I see that. I saw that. So IAC and HTRF are the same person, right? IAC wants to build a headquarters building, right? It hires Georgetown to help build the building. It leases the property on 12 and 54.
Right.
It pays to have a building built, and it's a tenant, okay? Bear with me. As part of the lease, at the time of the lease, everybody knew that there was likely to be a rezoning in the High Line,
Right.
okay? And everybody knew that the allowable space for the IAC lot, which was 5.0 at the time, was likely to go up to 7.5.
Okay.
So IAC, which is spending millions and millions and millions of dollars of rent, says, you know what, we're gonna be here for 75 years as tenant. We would like the opportunity, if the zoning goes up, that maybe we might wanna build a building on our land.
Ergo, you have the agreement that comes up, right? The letter agreement pops up.
The letter agreement, well,
Yeah, let's fast forward this a little bit.
fast forward.
The
Fair
letter
enough.
agreement pops
Let's
up.
go. Okay.
Exactly, because
So-
that's exactly what the plaintiff was, that was contemplating.
let's-
If you build it, well, I want a piece of the action if you build something.
well,
That's what they're saying.
that's what they say.
That's what this,
That's what they say,
This is
which
what-
we'll get to, what they say. But
Well,
what,
your time is running out.
you run time, so let's get to the,
okay, all right. So IAC never had anything other than a lease with a lease provision.
right.
Okay? Now, the rezoning happens. Now, all of a sudden, hey, maybe within 75 years, we'll want to expand. Okay? The letter agreement covers development opportunities elsewhere. Okay? It specifically says, if either party obtains a right to own land anywhere else, then, well,
It says a right or option to purchase or lease any other property. That's
Correct.
what Provision 2 says.
okay.
A right to own or purchase. So what
Fair enough.
Justice
Let's-
Doyne was raising is when they went and contributed $50 per square foot to the Highline Fund, that purchase got them an interest in more FAR.
Okay.
Yes?
No.
No.
You know why?
Why?
IAC never contributed to that. You know why? Related did all that. You know why? Because all IAC ever had was their lease. And all IAC ever did was, you say, you know what, we have this lease provision. If they, next door, want to build a bigger building next door, they can't do it because our landlord can't transfer this excess FAR from this property to them because they promised that we could use it, right?
Right.
So all IAC did was get paid to give back to its own landlord.
You're saying the contribution was made by related?
100%.
That you guys didn't put in the $50 per square?
No, never.
So but you would agree that HTRF Ventures paid the contribution?
No. Okay, all right. HGRF is IAC. They have the lease.
Yeah, we got that.
They give it up. Related, they give it up as part of the related transaction, which they've conceded did not trigger it. But here's what happened because we're all just to make sure we understand what happened in the related transaction. Related buys lots 20 and 29,
Yes.
right? Like I said, they want to build a bigger building.
Right. So they want your lots.
No, they don't want our lots.
They don't want your lot. They want your FARs.
They want the FAR from our property.
Yes.
Right? But we were already promised in our lease that we could use it.
Right.
Use it.
So,
not
yeah.
own it, not buy it.
Of course, so the owner of the property's got to come to you and you got to get your permission.
Correct.
Right. Yeah.
All right? So related pays the owner of our property to transfer it to them, pays us to give it back to the owner of our property. So the
You make
owner
two
of our
payments. So
property.
related makes two payments. One
Yes,
to the
well,
owner, one to you.
Yeah.
Oh, well,
And
that's
just so the owner being,
The owner is
reliance.
our landlord is Mendon, also called responsive.
Response. I'm sorry. Response.
Responsive, Mendon, same thing. Okay.
Not you.
Originally, when we first built the building, Mendon owned the whole block. Okay. You have our lot and you have the lot next door.
Right.
All right. Related comes along, pays $200 million to buy the lot next door, pays Mendon a few extra million once they've paid us to give our lease back to Mendon, so that now Mendon could say, look, all right, now we can actually.
They buy 2029. They need 12/54. They need your lots.
They don't need our lots.
They need your FARs.
They need, they need us to get out of the way.
They get out of the way. Got it.
by merging the, continue.
And the merger of the lots is essentially a zoning technicality that allows
The
the guy
FARs to
who-
be transferred
the
over to
person
the.
who
right.
has the.
So stop there 1 second. When you talk about zoning technicality, isn't it the plaintiff's contention that their work with the city facilitated the amendment to the zoning resolution that allowed the quote-unquote technicality to take place?
That's what they say. We'll give it to them. Okay.
So you do agree with that?
So
Well, I don't think it matters.
That goes to the unjust enrichment.
That goes to the unjust, which we can talk about the unjust enrichment, but that doesn't matter, but
That's
sure.
conceded.
Well, it's conceded
They
that
have an
it's
unjust.
conceded.
No.
I'm sorry, yeah.
They have an unjust enrichment claim that's viable against you.
That's not conceded by any stretch of the
I
imagination.
thought that's what you just
Why
said.
not?
No.
Why not?
No, what I conceded was that they did a lot of work in connection with the rezoning.
For free.
Excuse me?
For free.
Well, let's talk about why they did all that work, all right? There is a memo, an internal memo written by Joe Rose. I'll get you the record site in a second. But there's a memo that Joe Rose writes to his partners at Georgetown that essentially says, and spells everything out. And it says, we, Georgetown, have had a deal with Mendon. Remember who Mendon is? Mendon is the owner of the whole block. We, Georgetown, have a deal with Mendon so that we, Georgetown, we are going to lease the other lot. If we, Georgetown, are satisfied with the new rezoning. As part of our Georgetown's deal with Mendon, the owner of the other lot, we have expended considerable time and effort and energy and used all of our genius expertise to persuade the city to enact breathtakingly ingenious zoning changes that are so fantastic, but they're all because of all of the work that we've done pursuant to our handshake deal with Mendon. Mendon then comes back and they want to change it, but here's what we retraded, and we're going to continue with our handshake deal, which is why they did all of the rezoning work, because of their deal with Mendon. And what happened? They brought in Fried Frank, zoning experts. They arranged for Fried Frank to represent Mendon. Mendon paid Fried Frank to do all of that, all the zoning ingenuity. They'll claim like they're the geniuses. Either way, it doesn't matter, because their own internal documents contemporaneously prove up and down that all of the work was done pursuant to the handshake deal. They kept internal records in their own finances of expenses due from
That's a
Mendon.
long way of saying that the unjust enrichment claim doesn't fly because it was between Georgetown and the owner, not with us.
100%.
All the work they did was, that's them, that's wrong guy. You're suing the wrong guy for that.
100%.
Got it.
And
Thank you. Okay, we got it. Thank you. All right.
I need to correct a number of
Counsel,
Who do you represent? Who are you and who do you represent?
Paul Sweeney, may it please the court, on behalf of the plaintiff respondent, Georgetown.
Thank you.
Allow me to ask you, is this fact pattern as complicated as your adversary just indicated, or is it much more simple?
I don't know if it's as complicated, but what you were just told and some of the misimpressions of your honors, they're just inaccurate as to what happened here. So let me just clarify a couple of things.
Okay.
The letter agreement that the court below found there are ambiguous terms when applied to this transaction, this $35 million transaction, which implicated the 2005 rezoning.
Yeah, right.
There are ambiguities because of conflicting evidence and conflicting
got
expert
that.
testimony, okay? The 2004 letter agreement says that it kicks in if either IAC or Georgetown now has or hereinafter obtains, that's specifically referring to their knowledge that rezoning is gonna happen, a right or option to purchase or lease any other property, the adjoining properties, or an interest in other property.
And a transfer, in your view, is an interest?
They did not.
Counsel, and a transfer, in your view, is an interest?
Yes, the ability.
Transfer of air rights.
The ability to obtain the air rights, all right? That is an interest in real property.
And that was purchased through the contribution that was done to the High Line?
That was done by Related, but they didn't.
Okay, hold on a second. So who made the contribution? You're not disputing that fact?
Related did.
Okay, so
But IAC or Georgetown did not, that's not what the contract says. They had to obtain the right or option to purchase. It did not say, and you purchase. You had to have the right or option. And what's
The right or option
to
to purchase an interest in other property.
Exactly.
Not something,
And then it was not IAC's FAR. That
what's
is
the other?
absolutely false.
Okay, so what's the other property that they purchased or leased?
So you have to understand the rezoning. These bonus development rights only arose if the parties in interest, IAC, Georgetown, the property owner, consented to a zoning lot merger. You don't get the additional 2.5 FAR. Now, under their lease, they had a right to use 2.0. What Related obtained was a right of 2.5. So where'd that other 0.5 come from? It wasn't from their lease, it was from agreeing to the zoning lot merger under the rezoning.
but then if it's a merger, then isn't it their own property?
And then, yes, it's other property because once they've merged the lots.
That's not a purchase or a lease then?
No, it's a right to purchase.
But
Because
counsel,
once
air rights are property, correct?
a right to purchase,
Air rights are property,
an interest in property.
right?
And air rights are, under the law, an interest in property.
So that's additional property in your view?
That's
or
other property because it was to be used, it was a result of a zoning lot merger, and it was to be used on the adjoining lot. It was an interest that was to be used on the adjoining lot.
So,
And you could only buy it from the city at the $50 discounted rate if there was a zoning lot merger.
So
So
to make
Georgetown
this-
had to consent.
To make this simple, there is a difference between the property that was owned on the ground and the property that was up in the air called air rights, yes? It's two different properties?
Well, there's the IAC site and there's the adjoining site,
Mm-hmm.
okay? So there's, the IAC site is where the joint entity is the tenant and IAC is the subtenant, and there's neighboring property. Those parties had to merge their lots to have access to all of these zoning rights.
that would be Related doing that. Related is the one, this letter agreement, the way I understand the record, the way it sort of came about, is that this letter agreement was to protect or at least make sure that the joint venture guys, that would be Georgetown and IAC, that if you guys developed the property, that everybody was going to share on it equally, okay, 50-50. At some point in time, the legislation change came about, increased the FARs, and you could have instead of Related, you guys could have gone ahead and said, you know what, we want the other two lots, we want to merge it, we want to purchase those area, we want to combine everything, so that without question at that point, the letter agreement would be there, would protect both sides in terms of, getting a cut of a piece of the action there, right? But in this case here, there was a wrinkle here. Related came out of nowhere and said, you know what? I want to do this. I want to buy these two lots from the owner, and then I want the FARs from the other side. Well, you couldn't get the FARs from the other side unless there was a contribution made according to the legislation, right? The legislation says it was sort of a condition to getting those FAR rights.
Condition was the zoning lot merger.
I'm sorry?
The condition was the zoning lot merger.
Yeah, I get that, but are you saying that there was no requirement for a contribution to be
No, there
made?
was. That was the purchase of the interest in property, but without
No, that was,
Georgetown's
no.
consent-
You got to be careful about how you use the terms. The contribution to the Highline Fund was to allow the FARs to become real, in a sense, because until that contribution was made, there were no FAR rights to be coming into it. There were no increased FAR rights.
There were rights. You had the right to obtain them by making the contribution. And that's what the letter of
And if
agreement
you don't make the contribution, nothing happens.
But
Yes or no? I mean, that's an issue.
No, that is the next step. In order to actually obtain, you have to pay. But to have the right to obtain, you had to merge the lots.
So your starting point is that merger of the lots, and because the lots merged, that entitled you to the next step of the FAR rights contribution, regardless of who made it.
Correct, because when there's an agreement to merge the lots, that's when the parties have a right or option. In fact, that right or option started when the zoning was passed. This was conceived by Georgetown for the parties' mutual benefit. It is only because...
so you're saying it doesn't matter who gave the contribution?
Absolutely.
Because as my colleague was pointing out, once the 4 lots were merged, boom, the next step is just, whatever. But it's in a sense, the merger couldn't have happened unless HTRF, the sublessee, and the lessee, which was IAC, agreed to the merger.
And Georgetown. Georgetown's consent, it was a collective right.
Well, more importantly, the two of them had to agree, right?
Yes,
So that's where your point is. The point is once the merger took place.
Well, and we say, look, the collective right arose when the zoning was passed. As soon as these 3 parties agreed to a zoning lot merger, that was the only way to unlock all this additional FAR, allow it to be moved to the other lot, allow the increased height, and allow you to get it for $50 a square foot from the city, all of that.
That's all, yeah. I mean, at the bottom, the core point you're making is that none of this could happen, as my colleague pointed out, until the 4 lots were merged.
And Your Honor, that step was absolutely...
And that's all 3 of you had to agree with that.
The collective group had to. And you want to know how we know that IAC and Georgetown had the right to purchase an interest in other property? The agreement with Related is called the rights fee agreement. $35 million were paid to get the rights. IAC and Georgetown both had to agree to relinquish those rights. They're telling you the right in the letter agreement doesn't mean rights, or this doesn't satisfy rights. But when it was transferred, when it was relinquished, it was rights given up, and we say it falls definitely under right or option, which is what the court below found. Rights are often given up for $35 million. So IAC and Georgetown didn't have to make the purchase, but it was clear that they were the ones giving up the right or option to purchase to Related. That falls squarely within the letter agreement. And then the court below had expert testimony before it, and it had witness testimony on these specific terms, whether the meaning of right as it applies to the zoning resolution in this transaction. IAC and Georgetown expert disagreed. The meaning of option, their fact witnesses say when we negotiated, it meant an option contract. Georgetown said, no, it didn't mean an option contract. It meant an option. They had the option to merge lots and then be able to purchase the rights.
Thank you. You've been way over your time.
Can I just touch on just enrichment quickly?
Okay, real quick.
If this transaction falls outside of the 4 corners of the letter agreement, the subject matter is outside of those 4 corners, Georgetown clearly has an unjust enrichment claim. The contention that we were doing this work pursuant to an agreement with Mendon is just false. There is discussion in the emails or documents at the time that they had a handshake deal with Mendon to try to develop this property. With IAC, all of this was done because we thought we were partners, Georgetown and IAC. Georgetown conceived of this and got adopted. unlocking all of these very valuable rights, which we know are worth $35 million, unlocking all those contingent on a zoning lot merger, right? IAC and Georgetown had to consent. That gave them say over what happened on the adjoining property. And so Georgetown was acting for itself, certainly, but for IAC, it gave IAC the ability to obtain this $35 million. That's why it's unjust enrichment. Georgetown conceived of it, got it adopted because it thought we were partners, and that's why they thought they were supposed to share equally in it.
Okay.
And when they brought the transaction,
I think we got it.
Okay.
We got your sense.
Thank you, Your
you.
Thank you. I would submit that what just happened was a number of questions from the court that suggested that the right to obtain the FAR was triggered when the contribution was made.
No, I think that we were kind of saying that the merger maybe.
Right, but then
Okay.
he's saying the merger is the one that's the key, regardless of who makes the contribution.
That's what you think he said.
Well, that's what I heard.
No, well, I'm here to say that in his brief, he walked away from the upon the merger. And he also slipped in a few times, if you go back and read the transcript, no. It was upon the rezoning. It wasn't upon the merger. He then wants to talk about it, but his position, if you look at his brief, pages 42, 43, 41, 42, 43, okay? He essentially mooted and nullified Judge Reed's erroneous finding that all this happened upon the merger. He walks away and he said, no, this was years before the merger. You know why? I'll tell you why he runs from the merger, even though that was his complaint. He runs from the merger because when does the merger take place? The merger becomes effective in September of 2015, after the closing of the entire related transaction, after IAC's been paid.
After the contribution was made.
No. Well, after the contributions made by Related, after Related structured the entire deal to make sure that, look, if we're going to pay $250+ million for this thing, we don't want someone else coming along saying,
So the whole argument about the merger is just, it had nothing to do with anything. It was the key component was the contribution.
well,
Depending on which comes first, right?
correct. Here's the deal. The case, the only thing you need to worry about is whether this contract got triggered. And under the plain language, someone has to obtain a right to purchase an interest in the property next door. It sounds like it happened at the time of the contribution and the merger. He's walking away from that because he knows he didn't, because all that happened after IAC was paid to give up its leasehold right, which is the only thing, again, it ever had.
But can't any other property be read to mean the FAR?
Well, okay, so let me just...
That's what I thought at one point I understood your friend to say, was that the any other property, that, in quotes, any other property from the letter agreement, that property could be the FAR, because the air rights are property rights.
Let's assume that any other property includes air rights, okay? Fine. IAC was a tenant. It never had a right to do anything next door. It was paying rent on its property. It maybe could have been the one to make the contribution, but what would it have to do? It would have to persuade its own landlord to merge the lots next door, so IAC would have to pay for that. It would have to persuade everyone else to go along with its plan, and then it would have to, okay? It didn't. It never happened. Instead, IAC had this right in its lease. It got paid to give up its leasehold right, give it back to its landlord, and its landlord could do it, okay? So this whole thing upon the merger, that's not his theory. His theory is upon the rezoning before the merger. So let's go back to before Related comes in and pays for anything, okay? It's really hard to understand his theory. Look, believe me, we've had a hard time. But upon the rezoning, his theory is that upon the rezoning, now we all have these collective rights, including Georgetown, the developer, okay? What do? You go to the evidence. Here's the undisputed evidence. All of the owners of all the land testified. They were all asked.
You know what? I think we're getting down the road. We heard enough of the argument. Thank you. We got running out of time, but okay, thank you.
I have one practical question. if they had this right, they could exercise this at any time. What would happen when a tenant goes next door and knocks on the door of the owner of the building next door and says, hey, we had this rezoning, guess what? I have an interest in your land. What are the terms of that interest? What interest does a tenant have in the land that somebody owns next door?
Okay,
Right?
right, thank you. Thank you very much. Thank you. No, that's it. No, we can't do that. We don't do that. That's breaking with precedent. And no. Thank you. We got everything here. This is, we'll take it all back and look at it. Thank you. Experience New York versus 126 West 34th Street. Okay, counsel.
May it please the court, my name is Edward Taftani, and I represent Plaintiff Appellant Experience NY Now, Inc. I'll refer to it as Experience and Experience New York. By way of background, Experience New York was established to sell souvenirs in New York City to...
Yeah, so we understand that this is a force majeure situation. Your client had to shut down because of the pause, right? The pause that was put in place during the pandemic. Couldn't do anything, I mean, right? So he shut his business down. He had nothing, he couldn't do anything. He stopped paying rent, right?
Well, Your Honor...
And then the pause was partially lifted.
Partially the reason, right.
And then fully lifted, but why shouldn't, why was Supreme Court wrong in denying,
Well, the Supreme Court was wrong, first of all, because the force majeure clause was invoked because of the force majeure events, which were COVID-19.
Yeah, I don't think anybody disputes that. I think it's what happened after you came out of we had a post-pandemic situation, right? So that the rental, the requirement to pay rent came again? I mean,
well,
arose again? It's
COVID
not forever.
Just to piggyback on my colleagues posing the question, you were shut down from March to June of 2020.
That's correct.
June 2020, businesses like yours were allowed to have employees in the business and do curbside deliveries and various other things. So you could have functioned as a business from June to September of 2020. You could have, whether you did or not, but you could have, yes or no?
We could have opened.
Okay, and then you unilaterally chose to terminate your lease in September of 2020, correct?
Well, the decision was made to terminate.
Just bear with me, it's a yes or no, correct?
Correct.
Okay, so now the landlord is basically saying, okay, there's an existing lease, you made some unilateral decisions. The question is does the force majeure clause of your lease allow you to get off the hook completely the way you claim it can or not?
Well,
You said that better than me.
That's not entirely accurate. Our contention has always been the force majeure clause relieves the obligation to pay rent only for as long as the force majeure clause is triggered. The force majeure clause wasn't triggered or confined only to the pause period of time. It related to all the way through at least 2020, as my brief points out in pages 19 to 27.
Counsel, how? There was an ability to conduct business, and your argument basically is we sell souvenirs. There was reduced tourism in the city. Therefore, it didn't make sense for us to be selling our souvenirs, and it didn't make sense for us to keep our store open anymore. We gave up because essentially you're arguing it was impossible to do your business, not yours, but your client's
Your Honor,
business.
the trial court, what the trial court erred is it applied the impossibility standard or the doctrine of impossibility. That is not the same standard that should be applied in connection with the enforcement of a force majeure provision. In fact, it's pointed out in my brief, if you did that.
What gets you off the hook when the pandemic officially ends and people are able to resume, store owners, businesses are able to resume business? You say it wasn't really feasible for us because of the kind of work that we do. Tourists weren't coming into the city.
The pandemic didn't end in August of 2020. In fact, I contend just to the contrary. As again pointed out in the brief, in 2020, in December of 2020. The New York Marathon was canceled, and the.
But in terms of your business, the restrictions that allowed you, that closed your business completely were changed to now allow different, like maybe curbside service. We're not talking about the marathon and things like that. We know the pandemic, we're probably still all feeling the effects of some sort of thing from the pandemic, but that's not what we're here for. We're here about rent and your obligation to pay rent.
But all we have to show is that but for the pandemic, we would have been able to pay rent. And
Yeah, but here's my question then. At what point then would you argue that your rent would be triggered again? I mean, by your own argument, you're saying the force majeure gives you only a temporary protection, right? Not a permanent protection. So at what point, if you didn't terminate the lease, at what point would you say that your rental obligations get triggered again?
well, the answer to your question is, in this instance, we don't need to identify a specific point, because what happened in this case is that the landlord improperly sent the rent demand and drew down on the letter of credit during the force majeure provision, the demand. There was no default at that point in time. And that's why I made clear in at least the brief, all the way through at least 2020 force majeure existed. But when
Who decides?
Pardon me?
Who decides the duration of the force majeure?
Well, in this instance, I suggest that the court can take judicial notice of that in terms of
What immutable
Pardon?
what if we're going to take judicial notice, then what immutable, uncontestable fact can we take judicial notice of? Because that's the standard for judicial notice. So what date and what's the source of that date that we can point to? That's the concrete date that the pandemic ended for the purpose of this force majeure.
Look, the court could pick whatever date it deems appropriate. In this instance, one thing I know is that statute of limitations, they were, but for the pandemic, extended. And at a certain point in time, the courts decided that the pandemic no longer existed and that the statute of limitations
For my days,
effect again.
for my days of Part 52, you know, your remedy would not have been to terminate the contract. If you believe the landlord drew down on the letter of credit improperly and should not have done that, you know, your remedy would have been to commence an action then against the landlord, not to say I'm terminating the lease, right?
Well, I respectfully disagree, Justice Owen. When a party to a contract makes a material breach of that contract, it gives the non-breaching party the ability to terminate. And in this instance, I would suggest that the proper approach would have been just the opposite.
Did you file a Yellowstone?
Your Honor, we did not follow Yellowstone because I'm not sure that would be appropriate in this instance. What I suggest the proper approach should have been, which should have been for the landlord actually, to bring an action seeking declaratory judgment, in fact, that it had the right to terminate, or excuse me, had the right to draw down on the letter of credit. I know if I had been representing the landlord in this instance, I would have warned and said, listen, the force majeure clause has been invoked. You didn't object in any way for 7 months to this, and now out of the blue, you're suggesting that they've got to pay rent for April, May, June, July, and August. Each of those months, pandemic was raging. There was no business. Again, thousands of hotel rooms were permanently closed.
Okay.
I
got it. Thank you. Thank you. We'll give you all the time. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the Court. My name is Kim Weber, and I represent the respondent, 126 West 34th Street Associates, LLC, and I will try to be very brief this afternoon. I think there's a couple things that are really important with what Appellant's counsel mentioned today, and that was when Your Honors began asking, you know, what could we point to? What would we look to determine when the force majeure event ended? And counsel equivocated. Even today in argument, he said, at least. So he's not even sure what the court could point to. So how could the court rely upon that as a standard to move forward? And moreover, what impact would that have on the now unfortunately large body of case law concerning the COVID-19 pandemic, especially in New York City?
But a lot of those cases don't have this force majeure clause in it, right? Sometimes it falls on the side of, well, listen, you had this obligation to pay rent. Regardless, you guaranteed the rent. Regardless, you have to pay it. But we do have this clause that says, well, if something like act of God, a strike, or whatever, the rest of it, a war, that was the other thing. If that occurs, then, you know, your performance shall be, if it's delayed or prevented, you know, we've made some kind of provision for that. So that's
You're
what we're
right.
faced with.
You're right, Your Honor. There is that language in the force majeure provision here. The landlord certainly does not dispute, you know, the words of the lease. But I think what the court can look to, in addition to the body of COVID-19 case law that speaks specifically to the force majeure clause and the catch-all provision in that clause, is the Kel-Kim Corp case, which, while not in the context of the pandemic, speaks specifically to how a force majeure clause is supposed to be interpreted narrowly, and especially in a situation like this, where there are things enumerated in that force majeure clause. It's not not the job of this court to read what else might be appropriate into that language.
I think the problem I'm having is that you can't link force majeure up with a right to terminate. I think force majeure gives the tenant in these facts an opportunity to not pay rent because of during wherever the conditions are that will prevent that rent payment. But in this case here, and I mentioned this earlier, August 19, 2020, there was a rent demand served upon the plaintiff, right?
That's correct, Your
So
Honor.
that at that point, there's something up. So that what does the tenant do instead? From my notes, it says the plaintiff rejects it, saying, I have force majeure. Doesn't seek judicial, I mean, at that point, you could say, I mean, he's saying that you guys should have done something. It should have done something. But now I got served with a notice to pay rent. I'm going to go to court and say, I don't have to pay rent. What's going on here, right?
I agree with Your Honor.
At that point, so.
All right, so narrowly tailoring that clause would mean arguably April, May, June, because that's when the city-state orders shut them down completely. But then when June allowed for the return of businesses, and they could have returned to their business in June, and with curbside deliveries or whatever it is they needed to be able to try and promote their tchotchkes in the street. I'm not being pejorative, but. Ouch. So then that would trigger $70,000 a month for June, July, August, and September, and you had a letter of credit for $210, so more or less you would be able to draw down on it based on the default, correct?
That is correct, Your Honor. If that were the situation before the court, that would be correct. But, you know, in fact, as we know, the tenant went further than that here, and.
They terminated the lease.
Correct.
And without any circumstance that prevented them from doing their business.
That is correct, and in fact, the lease.
And by terminating the lease unilaterally, you believe they owed you the balance of the lease time.
That is correct, Your Honor. And the lease, its purpose and its use provisions specifically speak to the breadth of scope of other purposes, business purposes that the tenant could have done. The purpose was to use and occupy the premises for retail sales of tourist apparel and souvenirs, general merchandise, and food items and drinks. So
at the point where you issued the demand notice in August of 2020, do you acknowledge that no rent was owed during the pause period? Or do you include the rent that would have otherwise been paid during that period?
The rent demand included rent April through the time the notice was sent.
How do you justify that? Thank you. I appreciate that silence.
Thank you.
Justice Gonzalez, you're absolutely correct. There is no justification for that, and that's why the demand notice was faulty and the drawdown was a breach of the lease. And just to be clear, Justice Owen, we did not terminate the lease because of the force majeure provision. In fact, if we wanted to, that would have been done on March 16th when we invoked the force majeure provision. In fact, just to the contrary, we stated to the landlord that we're invoking it and only for so long as the force majeure is in effect, and we look forward to paying our rent when the situation subsides. To the other bigger issue about like how do we know when force majeure is over, that question would be applicable to every force majeure provision. Here again, I contend we don't need to look beyond the demand notice in August of 2020 because at that point in time force majeure was in effect.
Well, I mean, that's really the question, right? Because in June of 2020, restrictions were lifted, curbside retail was allowed. So why would the force majeure still be going on at that?
I don't, all we need to
And
show.
why aren't we just talking about the amount of money as opposed to that?
Justice,
It's fine, go ahead.
I'm sorry. I will repeat that, we don't need to show impossibility. We only need to show proximate cause. And I don't think anybody can reasonably say, but for the pandemic, rent would have been paid. It absolutely would have been paid, but for the pandemic. We've shown that rent was paid up to and through March of 2020. It's the pandemic. There's no way someone can plausibly argue that but for the pandemic, rent would not have been paid. And that's all we need to show. There is a case, a recent case in the federal court, I don't know if you want the citation, 23 Civ 5138, which is entitled Vinci Brands versus Coach, which cites also to another federal case in the District of Connecticut, Huth, and a Northern District case, where the court makes absolutely clear that there is a different standard that's applied with respect to the doctrine of impossibility, which is such a high standard where you have to show destruction of the property, that the premises no longer existed. Here, all we have to show is proximate cause, and that's what we've done. But for the pandemic, rent would have been paid. And my adversary here has acknowledged or has given no reason why the rent demand was valid, because certainly it includes months that the shutdown at a minimum exists.
Okay, thank you.
Thank you, Your Honors.
NYCLU versus New York State Office of Court Administration.
Good afternoon, Your Honors. May it please the court, Robin Rothman for Appellant, Office of Court Administration.
Gotta put the mic closer to you.
There you go. This is a Freedom of Information law matter that concerns a request for documents undefined by author or custodian, expansive in document type, and indefinite as to the subject matter, which fails to meet the reasonably described requirements of the Public Officers Law. The court below failed to take into account the proper weight.
So, counsel, as far as the reasonable description, your FOIL request asked for any decision analyzing or interpret any decision by OCA analyzing, or any explanation by OCA that directed judges to interpret cases, all federal, all state decisions, all federal or state statutes, regulations, or ordinances, and all policies, procedures, criteria, and/or guidance from OCA from 2011 until the date of the request. That is the most global request that could possibly have been made. So how could you call that reasonable? Where do you start and where do you finish?
Well, Your Honor, if I may just make one correction, I represent the Office of Court Administration.
Oh, you're OCA. Oh, okay, so my question is different. Was the memo in this case advisory as far as the judges are concerned? It wasn't directed to the court. It was directed to deputy administrative judges, am I right?
It was directed to the Deputy Chief Administrative Judges. Now, Your Honor, was specific to this particular memo and memos that are like that from that specific source, which is counsel's office. Those documents, which we explained in both denials as well as the affidavit provided by the court,
They're privileged, right?
were privileged, correct.
And their attorney work product.
Their attorney work product, and they were privileged communications because counsel's office represents not just OCA, they represent the entire court system, which is inclusive of judges, their staff, as well as other members of the court system.
You have a cite for that, authority for that proposition, that OCA counsel's office is basically has a general broad attorney-client relationship with all of the judges in the unified court system?
Well, Your Honor, that is explained on the website that we are part of not just OCA, which is really the administrative arm of the judiciary, and that citation really comes from the powers of the chief administrator, which is found in the Constitution. So that's where that comes from, and I think the best example is that I am from counsel's office. I'm standing here before you. I represent the court system, and I've represented other members of the judiciary and other litigation. But that's just me as part of the litigation team. There are other members of counsel's office that provides counsel to the court system that affects administration and operations of the court. Now, that goes to the new case rendered by the Court of Appeals, which is Appellate Advocates. And that specifically states that in-house counsel that produce advisory memos or advisory discussion, that's privileged. And in fact, in Appellate Advocates, which is entirely controlling as to that subset of documents, explicitly rejects what respondents here have suggested, that attorney-client privilege has to turn on materials that are rendered in anticipation of litigation, or it has to turn...
Let's assume that we agree with you as far as attorney-client privilege and work product. Let's assume that. What about the respondent's stated reason for bringing making the FOIL request, which is to say there is a concern that the Office of Court Administration is directing judges as to how to decide cases. And they say this is a matter of public interest, and this falls within a certain category that allows them to access these materials.
Well, I would, respond to that is that FOIL does not require there be a reason to obtain the records, right? Anybody can make a FOIL request for any purpose. There's nothing in FOIL that requires a requester to say, well, this is the reason why, and we think this is, of public concern. Certainly, government records are of public concern. But I think here, FOIL contemplates that not all government records are open for disclosure, right? They provide for exemptions, such as attorney-client privilege, or any statute that would exempt disclosure of these records.
Just classically, we're always involved with the issue of whether a particular FOIL request is overbroad in many of these appeals. Your adversaries acknowledge that their request was overbroad, don't they?
Absolutely, and I think
And they belatedly attempted to try and tailor it and narrow it after you went through that whole process.
Sure. It's our contention that most, if not all, of those clarifications came little too late. Those came during the Article 78, which was improper, right? Because what the court has to look at when you're dealing in Article 78 is the court has to look at the administrative proceedings before it. It has to look what was done and what was provided to the agency when it denied it. So these belated clarifications that were made during the Article 78, after OCA had already denied the requests, it shouldn't have had the court say, okay, well, they've narrowed it down now, which the court actually does state, and that's on the record. I believe it's record 268 of the joint, the supplemental record. The court actually says, well, they're narrowing it down now. Okay, but that's, again...
Didn't give you the opportunity to address it.
Correct, Your Honor.
Got it, thank you.
It's like raising an argument on appeal that was never raised
All
before.
right.
Yes, thank you.
May it please the Court, Terry Ding for the New York Civil Liberties Union. I just want to clarify the record about the scope of our request. Supreme Court found that we clarified our request not at the Article 78 stage, as my opposing counsel claims, but properly during the administrative proceedings. And we can point you to the part of the record, that's on record 46 and 47, where we issued those clarifications. And in fact, that's something that in their briefing, OCA concedes is permissible. And Supreme Court made that finding.
Counsel, I think one of the bigger issues here is this attorney client privilege, so maybe you want to talk to that before your time.
Yeah, I'm happy to address that. So I think it's worth considering that the staggeringly expansive scope of the attorney-client relationship that OCA is claiming here with every judge fails on its own terms. And you can see that from their own briefing. So their theory is that we, OCA, serve as the equivalent of in-house counsel to every judge throughout the unified court system. And this is how they explain how that works. So in their opening brief, they say, quote, counsel's office serves, correspondence between employees of an agency and its in-house counsel are privileged. But then throughout their briefing, throughout the record, they affirmatively represent that judges are not employees of OCA, right? Judges, as we know, if judges were, we wouldn't be able to, file OCA at all because the judiciary is exempt from the provisions of FOIL. So that analogy just doesn't work. And Justice Higgett, you asked for cites to demonstrate that there exists an attorney-client relationship in this context. So let me walk through what OCA has cited. It's two main things. The first is Judiciary Law, Section 212(1)R. All that section says is that OCA can, quote, establish educational programs, seminars, and institutes for judicial and non-judicial personnel. It says nothing about an attorney-client relationship. The second thing they point to is the affidavit of their FOIL officer, and this is on record 178. So he says there, quote, counsel's office serves the chief administrative judge and OCA in an in-house capacity. So
Now,
there's no mention of judges.
Let's take that for a second and accept that as true, because I think that certainly sounds fair and reasonable, assuming there's not some other broader relationship with the other judges. Wasn't the Crawford memo here directed to the DCAJs? Who would fall, I think, under the auspices of OCA?
That's right, Your Honor. So it was initially distributed to administrative judges within the administrative system. But we have evidence in the record that shows that it was then distributed from there to judges throughout the unified court system. And I think it's quite commonsensical if you look at its contents, that those directions were, guidance were directed towards judges who would be applying them in actual cases. So I don't think there's actually a dispute here that the guidance we're looking for has gone outside of the agency and throughout the court system. And of course,
I'm curious anecdotally. I know that it's not a requirement with a FOIA request, but we know anecdotally whether or not the Crawford memo was actually implemented, that your concerns that you raised were actually put forth anecdotally?
Yes, we also have evidence of that in the record, Your Honor. So we have an affirmation from a practitioner in the types of Crawford cases we're talking about, who talks about general observations since the OCA Crawford memo issued, and also talks about a specific case in which the defendant in a temporary order of protection hearing attempted to introduce live witness testimony, and specifically it was the complainant who was present and ready to explain that the whole case was a misunderstanding and that they did not want to issue an order of protection issued, and the judge denied that request. So there is that evidence in the record.
But did the order of protection actually issue? Because you're saying the complainant pulled back. So the judge denied the request to have live witnesses, but the complainant was saying it was a misunderstanding and didn't want the order of protection.
I can double check that. My understanding is that an order of protection issued in that case.
Well, you don't know. Your understanding. I mean, I'm curious because you said the complainant said it was a misunderstanding. The defendant wanted to put live witnesses. The trial judge at that point, if you're going to pull back as a complainant, why would we have live witnesses if you're not going to go forward with it, right?
Sure, Your Honor. But I think what's relevant for purposes of this case,
I was just curious, but okay,
is that it's undisputed that the Crawford memo has been applied. And of course the memo doesn't bind judges. It doesn't tell them to say did not, or impose an order in all cases.
It's careful when you're saying it's been applied. It's always up to the way I read the Crawford memo is that it cut back a little bit, that it's still up to the trial judge's discretion as to what's going on.
No dispute there, Your Honor, and that's why we call it guidance. It's not sort of a directive.
It undercuts everything that you're arguing, though.
I'm sorry?
I thought that was your prime concern. That's what I read in the brief, that you wanted transparency as far as how OCA was directing judges to decide cases. And you've said in different ways just now that OCA, in this case, the document that was issued by a deputy counsel of the office of counsel to OCA was a guidance. It was not a directive. So I honestly don't understand where you're going at this point.
Well, so I think a few responses to that, Your Honor. The first is that I would make a small but important amendment to your statement, which is that we are interested in transparency, which is what FOIL is all about. But we're interested in understanding the ways in which OCA issues guidance that informs cases like this. Of course, for FOIL, it doesn't matter if the guidance is binding or not.
Yeah, but you know what? You overlook a very important, to me, an important fact. The appellate division's here for anything that goes down in the trial court gets appealed. So if there is an abuse of discretion, like you said, if the trial courts if they're arguably following the Crawford memo and not giving full-blown hearings, I don't think this court would hesitate to reverse that in the sense that that would be against what we issued in the Crawford decision. You see what I'm saying? There's always a check, but when you talk about discretions, I think this court is fully aware of what we need to do to rectify anything that doesn't go right, in a sense.
And I believe that too, Your Honor.
Right, so where you this FOIA request to me is like I don't know. Yeah, I don't know where we're headed with this. So you find out with this FOIA, you get all these documents that, let's just say we direct them to turn off everything. Where are you going to go with that? Because at the end of the day, if the trial judges are actually, I don't think they are, but they actually are following what the Crawford memo is doing, I don't think there's anybody on this panel here would not hesitate.
I was on the Crawford panel.
Would
saw that.
reverse them so fast that their head would spin.
So I want to be absolutely clear on a couple points. One is that FOIL, it doesn't matter for purposes of FOIL, the purpose of the request.
I understand that.
I think that's your best answer.
Yeah, that's right.
It's none of your business. This is, I say that this is publicly available information, and under FOIL, I get it. Now, there may be good reasons that relate to what you are, what in your vocation in the law, that it may help you. But as a member of the public, you have a right to this information, provided it is not otherwise privileged. Relevance is not a standard here.
That's exactly right, Justice Higgett. And the other issue here is that as much as I believe in the ability of the appellate division to step in and correct any errors on appeal, if we just look at the Crawford example, that concerns temporary orders of protection. So it means that people are if they're erroneously separated from their families, they're kicked out of their homes, it takes time before that can be corrected on appeal. So there's real harm to people.
That's what we're here for.
Thank you.
And it takes time. And if I may just make one final point just on the reasonably described issue. OCA knows exactly what documents we're describing in our amended request. If you look at their brief, the reply brief, they say, quote, NYCLU's clarifications today do identify a subset of documents.
But that was later, after the administrative process.
That was during the administrative process, as Supreme Court found it. And again, that's at record 46 to 47. So just
there's always the old saying, be careful what you wish for. They could do a huge document dump and you can have like a warehouse of documents coming in. And what are you going to find from all that? As my colleague says, it's none of your business. What do you care? But
and we actually, I'm glad you raised that point, Your Honor, because we actually think we're talking about a very narrow and circumscribed set of documents here. Because what we pointed out in our briefing is that with our clarified request, this legal guidance to judges could only have been issued by a small number of senior attorneys within OCA. And that's not something that OCA has done.
Last I look, I don't think senior attorneys tell judges what to do, but thank you.
And again,
I got it.
We say
Thank
just
you.
Guidance. Thank you, Your Honor.
Your Honors, I would just like to make just a few brief points, and specifically to Justice Higgett's point it doesn't matter what the purpose of FOIL is, right? So when we talk,
I think you acknowledge that up front.
You're absolutely correct, Your Honor. But what they say is clarifying the request in their administrative appeal. All all they did was state, their clarification really was, all they stated was their reasons for wanting it. That wasn't really clarification because they never actually disclaimed the actual language of their FOIL request. So if they were willing to disclaim certain portions of their FOIL request and just state that OCA wants guidance to judges, that you know, whatever it may be, then we may have a different result here. But that's not the case. The case here, they never sought to disclaim any form of their request. They kept it as is, and they doubled down on it 3 paragraphs later in their FOIL appeal. Now the other point I'd like to make, especially, you know, and I think it's been discussed fully, is that this is purely guidance, and this panel before me is the panel that reverses or affirms a trial court. We cannot tell a judge what to do. OCA attorneys, senior attorneys, which again was only offered during the Article 78 proceedings, we cannot tell judges what to do. So even if we were to accept this clarification that it was guidance to judges, that still is overbroad, and we still can't.
Well, is the problem there trying to ascertain what is guidance? Is it some of these verbs are kind of amorphous or ambiguous, and so, you know, one person's trash is another's treasure. What's directive? What's something other than directive? If maybe there were more concrete language used to describe the nature of the documents, would that have allayed some of the OCA's concerns in responding to this?
It could have. Again, that's not really before us here. If they had provided different language, as I said, there might have been, you know, a different result. And I think that was one of the points made at oral argument in Aaron Law with Justice Owing. You made that point in one of the other cases where we're talking about
Remember what I had? Okay, that's fine.
unreasonably described records. He said if this was a little bit more described and there wasn't such a global understanding of what we're talking about, sure, there would have been
You know,
a
look,
result.
to put it in perspective here, they asked for document going back to 2011. The memo was dated 2021. Goes back on 10 years, a decade before. I mean, you know, right there and then was a huge net that's being cashed. If they had asked for all documents at that time for 2021 going forward, maybe, okay, perhaps a couple of years to see what's going on. But to go all the way back to 2011, boy, I tell you, that's a lot of documents there that, I don't know, and Crawford wasn't even issued yet at that point. So what are we even talking about, right?
Certainly, I would have to fully agree with that point, Your Honor.
Okay.
And,
All right.
you know, with that, I rest on my
Thank
brief.
you.
Thank you.
Great Rock versus Wingtip.
Good afternoon, Your Honors. May it please the court, my name is Emily Anderson of Shepherd Mullen. I'm here for the defendant appellant, Wingtip Communications, Inc. The CPLR only permits a plaintiff to bring a motion for summary judgment in lieu of a complaint in very, very narrow
Okay, so
circumstances.
from my understanding of this, of your argument, is that it's the date that we're talking about, right? The date saying January 31st, 2019, and I think the argument is that when you're doing a 3213 motion, these dates, these payment dates have to be accurate. You can't have a problem as you have here, because the third payment date arguably should have been January 31st, 2020, but it says January 31st, 2019, right?
That's one of
the
our
ambiguity.
arguments,
That's
yes.
one of your, that's a big argument, because the other arguments about the counterclaims and the defenses, the provisions in the agreements here kind of like puts those on the side, don't you think?
Well, it's also the effectiveness of the Second Amendment entirely, because there are conditions precedent to the effective date.
Right, so you're still pointing to that date that's incorrect, or that what
No,
you're saying
no,
that
no.
is proper?
I'm talking about Section 3 of the Second Amendment, which specifically says this amendment shall become effective upon the satisfaction of the following conditions precedent.
Yeah, but those condition precedents run to your client. They're not from condition precedents that the plaintiff has to satisfy. The plaintiff's only condition is that they got to make the loan available. All the other conditions are checked off by your client, right?
So
How can
I
you
would,
say
ag-
that- where's the failure of condition where's the condition precedent that the plaintiff failed to comply with?
right, so I'm not talking about the conditions precedent to repayment.
Okay.
I'm talking about conditions precedent to the contract ever coming into existence.
And what are the condition precedents for the contract to come into existence that the plaintiff failed to satisfy?
That I mean, these are not just for the appellant's benefit. These are for the.
What are they?
What are,
counsel? What are they?
What are they? The agent shall have received this amendment duly authorized, executed, and delivered by the borrower, guarantor, agent, and each lender, and the same shall be in full force and effect.
okay, so the lender checks off that box, it does what it has to do, then you guys have to accept and everything, check off that box. What's the next thing for it to be an executed agreement?
Agent shall have received that certain limited forbearance and First Amendment to the personal guarantee, so that's not wingtip, the appellant,
Okay.
of even.
Was that done?
I'm sorry?
Was that completed?
Well, I'm not sure because there was no discovery, right?
The loan was made though, correct? The money actually was, the loan, the $15 million was provided to your client, correct?
Correct, and the repayment date on that original loan was November 2021.
Correct.
Which had not occurred
Yes.
at the time that they sought to enforce the Second Amendment.
Right. So the First Amendment said that there were defaults that, according to my reading of the First Amendment, was that the borrower did concede or acknowledge that there were certain defaults, whatever they were. I don't remember what they were, and they entered into the First Amendment. The Second Amendment kind of carries that over again, that there were defaults. No defaults at all? The Second Amendment made no mention of defaults?
The First Amendment was not due to, the First Amendment was not due to the defaults that are at issue here. The First Amendment, it was the Second Amendment that set forth what the alleged defaults were.
Counsel, were any payments made here as to,
Under the
At
original.
all? Were
At
any
all?
payments made?
I mean, well, first of all, there wasn't
like a dollar?
discovery here. So, but
But
the.
You would know.
the-
It's your client, right? You would know if you paid money or not, because that would be the first thing you said, hey, we're not in breach, we paid all the money.
They were
You would
not in
know.
breach of any payment obligations
paid the
under the
money?
original loan. The Second Amendment.
Because your client paid the money or not? I mean, don't even answer that.
It's very, I mean, the Supreme Court, I read Justice Reed's decision. I mean, he's like, okay, we're running around in circles here. Did your client pay the $15 million or not? And the answer was, finally, no. So that, he said, where are we going here? That even if I find there's an ambiguity, at the end of the day, we're still going to be stuck at a situation where your client, if it's not a 3213, it's going to be at some point, you got to pay the $15 million back, right?
The $15 million was not due yet. The $15 million was due, the maturity date was November 2021.
But there was
The
an
Second Amendment.
acceleration- But there was an acceleration because there was a default in repayment. So we're trying to ascertain whether there's any wiggle room here for your client, as in whether even the dollar was paid. Was any money paid at all? When, please?
The acceleration was not made due to a default in repayment. If you look at the whereas clause of the Second Amendment that sets forth each of the events of default, they were due to delivery of financial statements and disclosure schedules, and all relating to that sort of nature, not due to a failure to miss a payment.
Okay, thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Nicholas Lagerman from McElroy Deutsch on behalf of plaintiff respondent Great Rock.
So the Second Amendment was entered into for whatever reason it was. That's now the controlling document, the Second Amendment, right?
The loan agreement as amended by.
As
but
amended
yes.
by the Second Amendment. And the Second Amendment had new payment dates in there, right?
I'm sorry?
The Second Amendment had new payment dates.
Well, yes. Slightly different, Your Honor, in that the Second Amendment, instead of proceeding for a default for the outstanding principal and interest and fees and everything that we were entitled to, the Second Amendment set up a different payment structure whereby Wingtip was obligated to repay the principal balance in 3 equal payments.
Right. December 16, 2019, December 31st, 2019, and this January 31st, 2019.
Yes.
And that is where one of the arguments is that because that's an ambiguity, you're not entitled to 3213 relief.
That is the argument that they've made, Your Honor, but the IAS court below correctly determined that it was going to read the agreement as a whole and said that a scrivener's error is not a basis for avoiding 3213 treatment when the contract, when read as a whole, makes clear what the date is.
And in fact, this Second Amendment wasn't executed until November 22nd of 2019, making that January 2019 date, if we were to read it the way that your adversary wanted us to read it, we would be somehow going back in time.
Exactly, Your Honor. And to that point, as the cases we've cited in our brief from this court have held, for there to actually be an ambiguity, the party claiming something is ambiguous needs to offer a reasonable interpretation. To Your Honor's point, it would be, in our estimation, completely unreasonable and absurd to think that an agreement would call for a payment to have been made 10 months before it was executed.
Well, probably in light of, that could be true in a vacuum, that 10 months down the road, but isn't here the fact that the clean down date was tied to that January 31st, 2020 date? I mean, isn't that what really makes it clear as a matter of law, unambiguous as a matter of law, what the third payment date was? Was that it was tethered to this other, I think it was milestone?
Yes, Your Honor is exactly right. And then when you look at I think it's Section 1 of the Second Amendment.
2HF? 2HF is where it says the final amount paid is January 31st, 2020.
Yes, and it ties back to the original thing that my client agreed, which was to forbear. And we agreed we would forbear so long as they met the milestones by the date set forth in the definitions.
I mean, they could have paid everything up on January 31st, 2020. They could have just dumped $15 million back at you at that point, right?
Your Honor, my client would have been thrilled. And it would be thrilled to receive its money back now. I think Your Honor's asked a number of questions about
Yes, how much money did they pay?
0.
So
there had been a few interest payments that had been made, I think, through 2019, but they have not paid back $1 since then.
So what is your response to your friend's argument that there are all these condition proceedings that had to be satisfied, they weren't satisfied, this agreement never came into being, it's not fully executed? What's your response to that?
Your Honor, the response is, I think, to the questions that the court was asking, which is that all of those conditions, every single one of them, was due to be performed by Wingtip or the guarantor who was their sole shareholder and owner. Every one of them. And as we cited, and the lower court correctly recognized, cases from this court, including the Park Union and the Stevens versus Flo case, and there was another one, I forget the name, that was issued recently, but it's in our brief, that make clear that the failure of a condition, that make clear that conditions are not a bar to 3213 when there is no performance obligation on the part of the plaintiff, that they are all from the defendant. And that, of course, flows into longstanding New York law, including the Court of Appeals decision in MHR Capital cited in their brief, that a party cannot rely upon its own failure to perform a condition precedent to avoid a contract, which is exactly what they are asking for here.
I'm sorry, are you able to switch gears a little? Can you point us to any authority where a court has corrected a scrivener's error on a 3213 action motion?
I have not. I don't know of one off the top of my head, Your Honor, but at the same time, I am not aware of a case that supports their proposition, the idea that when you have an agreement that admittedly has a scrivener's error,
But there are other portions of the agreement that make clear that that was an error and what the actual date for repayment is. There is no authority that I've been cited to by the other side that said that 3213 would be inappropriate. Here we think the contract is clear in the context as well as in the definitions of milestones. Everybody knew. And anybody with common sense would know that when you sign an agreement that calls for 3 payments going forward, that you can't have the last one precede the agreement by 10 months. Your Honors, we submit this is a case that was tailor-made for 3213. There is no dispute that there was a written loan agreement. There is no dispute that the amendment called for a series of payments, and so the loan agreement, as amended, was an instrument for payment of the money only. Your Honor, may I briefly conclude? Yep. There is no dispute of a default and non-payment. We established a prima facie case. It was on them to demonstrate an issue of fact. They have not done so, and they cannot do so. Okay. And we request that you affirm. Thank you.
Thank you. Civil procedure has to count for something. There were issues of material fact here. CPLR 3213 is only appropriate in a very limited set of circumstances. The appropriate answer to this is there were ambiguities in the final date of repayment. There were ambiguities as to whether in issues of material fact as to whether the Second Amendment was ever even in existence. And summary judgment in lieu of a complaint should have been denied. Additionally, January 30th.
I have one question to ask then. So that the original maturity date was November of 2019, yes?
No, the original maturity date was November of 2021.
2021.
And this lawsuit was initiated earlier in the year in 2021. We've got the
before November 2021.
Before November 2021.
Okay.
So additionally, to add insult to injury, the trial court improperly and sua sponte dismissed, without even the submission of a pleading, the affirmative defenses and counterclaims of the appellant for fraud in the inducement, economic duress, and breach of fiduciary duty. And the reasoning was that the original—
Why was there a fiduciary duty between a lender and a borrower?
There's normally not a legal relationship between a borrower and a bank. That does not normally create a fiduciary duty, but those authorities do not support that a fiduciary duty can never exist between the parties. Where there's evidence that there's a relationship, that the relationship is not usual between the borrower and the bank, it's possible to find a fiduciary duty, and that's Scott versus Dime Savings Bank of New York.
What would be unusual between this borrower and lender?
Well,
or is that discovery? Is that your answer?
It is, but but for good reason, because they inserted people to work at the business and gave them advice, and there's plenty of things that had we been able to even file a pleading containing the counterclaims that we could have written. Instead, without even receiving that pleading, without receiving an answer with counterclaims, it was dismissed. So additionally, I just want to say, in terms of the ambiguity with the January 21st.
I think thank you.
Okay. All right. Thank you so much.
We got the gist of your argument.
Thank you.
Thank you. People versus Damon Smith.
Good afternoon. Rachel Lindy from the Office of the Appellate Defender on behalf of Damien Smith. The trial evidence of physical injury was legally insufficient to establish that element of Mr. Smith's second-degree robbery conviction. The trial court itself characterized the minimal evidence of substantial pain that was presented as, quote, on the borderline. The complainants gave only brief and vague testimony that did not articulate any amount of pain that he felt or for how long he felt any pain.
I thought he testified that he felt pulsing for 1 or 2 days, right? He felt pressure building, pain pulsing around the eye a day or 2 later.
His testimony was that a day later he felt that. He didn't say how long that lasted. He didn't say if it lasted.
That's a day later.
That is,
Are you saying that that's not sufficient?
That is not, without indicating how much pain he felt, again, because, you know, even if he felt that, if he's saying he felt that a day later, he is not saying that any amount of pulsing and pain that he felt was more than slight, which is required for a substantial pain finding. And in addition, his other testimony indicates that any pain he felt was no more than slight.
So I have to make one correction. I looked at the trial court's decision here. He wrote a written decision because there's a trial order dismissal, right, after the verdict came in. And he says, with respect to the injury here, he says, based on the victim's description of the incident and his injuries, as well as after viewing the photographs of the injuries taken a few days after the incident, the jury could have found that the defendant caused the victim to suffer physical injury. So it didn't, I mean, he may have said something on the record, but in his written decision, he totally says something different.
I believe that it's on page 3 of the written decision that he describes it as on the borderline. I'm happy to return
I'm
to
looking
the
at
record on
page
that.
3 right now.
Nevertheless,
I'm just trying to correct the record here, but okay, I don't see it.
regardless, that was after he had also said that this was very close. And this is because...
I understand, well, everything you say, I'm not disagreeing with you, but I'm looking at his written decision afterwards. Whatever he says ahead of time, he's changed his mind later on in the written decision. But that said, I mean, here, the victim did testify, the complainant or the person that, the injured party did testify, he got punched in the eye, right?
And he testified to being hit seemingly one time. He did not say how hard he was hit.
From my standpoint, the eye is a very sensitive, the most sensitive part of the face. It's not like he got hit in the cheekbone or in the mouth, hit in the eye. I mean,
And you would think from...
And I saw the photograph. There's a nice little bruise underneath his eye.
And as you said, it's quite little. It's quite narrow. It's
Oh, I didn't say it was quite little.
slight.
That's your word. I didn't say that, you know. But, I mean, he testified that it was swollen, there was pulsation. We all know there's case law out there when it talks about substantial pain, it's relative. I mean, some person can tolerate the most excruciating pain. Other people, the slightest pain, they're already screaming for, you know, first aid, right?
That's exactly right, Your Honor. But the subjective experience of pain is relevant to that determination. And he indicated that he did not receive any medical treatment whatsoever. In fact, he did not.
Case law doesn't require it to meet the element of physical injury. You agree with that?
I do. I agree that that's not dispositive. However, it does indicate this court has looked to the fact that not just receiving no formal medical treatment, but not treating any pain whatsoever. And here, he did not even testify to recalling taking any Tylenol. He did not recall taking any ice.
And in other cases, maybe there's been testimony where, you know, on a scale of 1 to 10, how did you feel? Was it a 7? Was it an 8? And we don't have that here.
That's exactly right, Your Honor. And in this court's decision in Quito, similarly, there was some testimony that it hurt, but this court looked to how minimal that testimony was and the fact that there was no treatment whatsoever, including ice or over-the-counter
Was that
pain
explored
medication.
further on cross-examination of the victim when he was on the stand? Did defense counsel explore that area further? Because although this is what he testified to, the defense counsel further, you know, undermined, or at least
Well,
testimony.
The better question is, would a defense attorney ask that question?
That is a good question, Your Honor. And what we're looking at here, it was the prosecutor's burden to establish this physical injury element. And so we're looking at what evidence the prosecutor established. And there is no evidence here that he received any treatment whatsoever, that any pain that he felt was enough to interfere with any of his life activities, including sleeping, eating, which has been found relevant in other instances. In fact, he returned to work later the same day and returned to work as usual the following day. And I'll
Thank you.
respond more on rebuttal. Thank you.
Good afternoon. May it please the court, Faith Petrolio for the people. Defendant's conviction should be affirmed.
Counsel, just reading the record as to what the witness testified to about his injuries and then comparing it to some of the cases that have come out, especially in recent times, where there is some sort, even though there's been some sort of trend towards some quantifying of their injury, how they felt, the length of time. It was a 7, the pain of 10, I couldn't do this, I couldn't do that. We don't have that here. What we have is maybe 3 lines of testimony in terms of what the effect was on him. Is that sufficient?
Yes, it's more than sufficient here. The victim testified very clearly, not to an exact number out of 10 or that his pain was moderate or severe, but he used more specific words. He said his eye was pulsing, there was pressure building in the eye and up to the eyebrow, that he had pain, that it was puffy and inflamed, and that he had a bruise. And this is even a day or two after he was punched in the face. So although it is a brief exchange on direct, and to your point, Your Honor, it was explored further on cross. I believe very, very briefly it was.
I don't think it was.
Okay. From my recollection, I believe it was very briefly addressed on cross as well.
I don't think it would need to be, but I don't think it was. Anyway, continue.
Okay. And there was a photo of the bruise as well to kind of confirm the victim's report that he had this bruising underneath his eye a day or two after he was punched. And so that is sufficient to show that he was in substantial pain. Additionally, the evidence shows that the defendant intended to forcibly steal the victim's phone, and of course, the bruising and everything was the result of that. So the evidence pointing to that would be that defendant stopped the victim on the sidewalk and demanded his phone. When the victim did not comply, the defendant chased him down the street, grabbed him by the shoulder. When he still did not comply, defendant put him in a headlock and ultimately punched him. So I think the evidence is legally sufficient and does comport with the weight of the evidence to show that defendant did commit an attempted second-degree robbery in this case. Just to briefly touch on the suppression issue, there was probable cause here. The officer was approached by a person on the street who informed him that there was a robbery taking place inside of a coffee shop.
Ultimately, the mistaken testimony, the challenge testimony is the officer thought that the defendant handed him the phone when it was a third party that handed him the phone. But that was alerted, that was brought to the suppression court's attention before the officer even testified.
That's correct, Your Honor.
At that point, it's left to the trial court, and everybody agreed to allow the officer to testify what he was going to testify to. And at that point, the court just made a credibility determination as to whether or not, he found the officers credible, not requiring the people to call additional witnesses to just prove that point that they already conceded was a mistake.
Right, that's exactly correct, Your Honor. The people were not required to present an additional witness because the record was already corrected before any witnesses even testified at the suppression hearing. If there are no further...
Yeah, you would only need that if there wasn't brought to the court's attention, and you need that because that's a credibility determination that would go towards the credibility determination that the court would make with respect to the officer's testimony. If it happened the other way, like no...
If it had happened the other way.
Thank you.
You would need to correct the record in some way, but here it was, so thank you.
Just one point briefly on the question as to the sufficiency of the testimony. The adjectives that the complainant used, the few of them, did not, again, as stated before, did not lay out the degree of pain that he felt, as the Court of Appeals noted to be relevant in matter of Philip A. and again in Chittick, in articulating that its substantial pain finding was in part due to the fact that there was a specific amount of testimony to feeling between a little and a lot of pain. None of that is present here, and again...
Your adversary argues that rather than use metrics to describe the injury and the results, right, the victim chose to use descriptions, a different way of describing the injury. Is that enough?
Without more, and that more is not present here, I mean, I have not found a single case that would say that that is enough given what else is not here, given the fact that there was no medical treatment.
In other words, pulsing pain for 48 hours and pressure buildup in an eye, that doesn't suggest something going on?
He didn't say that it wasn't, there's no way of
I mean,
knowing.
if you say you couldn't find a case that describes pulsing pain for 48 hours and pressure buildup in an eye, where
There's no way of knowing how that was more than a little pulsing, a little pressure, without something else showing his subjective experience of pain, and we don't have that here. He didn't.
Counsel,
again,
I don't see a little pulsing or a little pressure. That's little is your addition, yes?
I'm saying that there's no way of knowing that what amount he was feeling without him articulating the amount that he was feeling. And again, what we do know is that he didn't recall taking even any Tylenol. He didn't recall.
Okay, got it, thank you.
Thank you.
Stay warm, folks, it's cold out there.